ಹೀಗೆ ಇದ್ರೆ ಜಮೀನು ಪ್ರಾಪರ್ಟಿ ತರ ನಾವು ಹೊಡೆದಾಡ್ಕೊಂಡಿದ್ರೆ ಆಗತ್ತೆ ಸರ್. ಏನೋ ಒಂದು ಕೈ ತೊಳ್ಕೊಂಡು
என்ன அளவுக்கு தெரியாது, எனக்கு தெரியாது மேம், வேற வழக்கு.
That's why we are requesting. That's how the sequence is.
But
second week after.
I am ready, my lord. I will commence my argument. Your lordship permits me, my lord. I'll take at least half an hour because the issue is only on a question of law. Whether section 13 of the Act, my lord, has been proved to be non-conclusive of the foreign judgment. Only to that effect. It's only a legal issue, not on facts.
We'll have that someday. We'll not hear on installment.
Any day.
Same day we'll hear and finish up the matter.
Even tomorrow, my lord, I'll come there, my lord. If your lordship permits me, even tomorrow I'll come there by 2:30. If your lordship permits me, I'll come there. Even today I am ready, my lord. If your lordship wants me, my lord, I will commence my argument. I'll not take not more than 15 to 20 minutes. Lordship is posting it, my lord?
Yes, posting to some other day. Tomorrow you are most welcome to Bangalore. Bangalore is a beautiful city.
It is very difficult, but it's cold also because we are a little sunny here at Madurai. Lordship, I have it on 12th, my lord. 12th or 13th. Next week by 2:30, my lord, I'll be there.
26th.
Lord,
26th.
27th, is it possible? my lord?
27th.
27th.
26th is too long, my lord. Your lordship, have it on 12th, 13th, my lord, I'll be there.
No,
30.
brother, we have some difficulty because other matters of, other older matters are being heard now.
Because this is 20 years, my lord, the person is suffering from not able to execute the degree. That is the
My lord,
problem.
after
2004 was
10
the degree.
years, it has had its first posting. Till then,
No,
office
no,
of
you
the-
did not
we do
appear.
know
He
why.
did not appear because he filed a quash application and only
Don't
there,
waste
my lord,
morning.
they have
Brother,
been compelled.
brother, I have a small prayer to you. In the
Yes.
morning, the productive hours should not be wasted for adjournments. Well, we are fixing it.
Lordship, have it on 13th, my lord, 2:30.
27. 27.
Lord,
Yes.
May I request? Fresh matter, my lord.
Yes.
Urgency is articles of charge. It was stayed by the tribunal. Now it is dismissed. They have called us for enquiry.
ಯಾವತ್ತಿ?
My lord, enquiry is posted next week.
Next one. ಯಾವ date?
Next 12th or 13th.
ಅಲ್ಲ, ಯಾವ
13th.
date? ಕೊಡಿ, ಯಾವತ್ತು enquiry notice ಯಾವತ್ತು?
My lord, enquiry notice is issued for us to appear before to give our reply to the articles. 30.
Next week ಯಾವಾಗ?
Please.
ಅಲ್ಲಿ enquiry ಮಾಡೋದ್ರಿಂದ ಏನ್ ಕಳಗುತ್ತಿದೆ ಅಂದ್ರೆ ಫೇಸ್ ಮಾಡಬೇಕು.
Arbitration matter, my lords.
Yes, brother.
Arbitration matter, IA 8 is rejected by the arbitral tribunal. my
ಏನ್
lords.
ಬೇಕು?
15th, my lords, kindly have it on 15th.
15.
Yes,
Arbitration ಯಾವತ್ತಿದೆ?
Arbitration next month ಇದೆ, my lords.
Next month.
ಹಾ,
2
yes.
weeks ಹಾಕೊಳ್ಳಿ.
Kindly have it on 15th, my lord.
15th. Next month ಅಲ್ಲ.
ಅಲ್ಲ,
Before that, we will take up the matter. Sorry.
Lord, fresh matter, my lord, where arbitrator has allowed an application to inquire, Lord, permitting the claimants to lead additional evidence.
Ah.
Lord, we have questioned that particular, my lord, the very validity of that request. And we have opposed it on the ground that, my lord, there is admittedly, my lord, in the contract itself, there is a clear cut, my lord.
Correct. ಅದು ಅವಾರ್ಡ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಅದೊಂದು ಗ್ರೌಂಡ್ ಆಗುತ್ತೆ.
Please, my lord, I have taken additional ground, my lord.
After 2 weeks, sorry.
My lord, may I make submission? On
Yeah,
12th, my lord.
Otherwise, you will have it now and we will dismiss it because it's covered by the judgment.
Please, my lord, I have taken one other ground because on the merits itself, my lord, the arbitrator has gone in detail. And my lord, my defense has been, my lord, struck off
Next week. Next week. Okay.
on Monday, my lord, because 12th
But
is the matter.
ಯಾವತ್ತಿದೆ? Matter ಯಾವತ್ತು?
12th is the
12th evening,
morning,
morning.
11:30, my lord.
ಹಾಕೋ.
Grateful.
My lord,
Ah.
BDA matter, my lord, I am for the respondent BDA. My lords, here, they have called in question, my lords, case on a committee reports, my lord.
ಯಾರು ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಪಿಟಿಷನರ್?
I am for the respondent, my lord.
ರೆಸ್ಪಾಂಡೆಂಟ್.
I
ಯಾವ
filed
ಇಯರ್ ದು ಮ್ಯಾಟರ್ಸ್?
2023, my lords,
23.
23.
23.
My lords, I have filed a vacating, my lords, because the allottees are coming to the BDA and regulars are paralleling with the BDA, my lord.
First week of December.
Any date may be fixed, my lord.
Worth date ಕೊಡಕ್ಕೆ.
Much.
Next. Next, Jayaprakash. ಅದು ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಹಾ.
But in this case, I had applied for the certified copies of the exhibits. The exhibit D series is not given because the defendants have taken back the documents.
ಯಾವಾಗ
I
ಎಷ್ಟು- ಯಾವಾಗ
request-
ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು?
Mother, without the certified copy, I cannot, Mother, may I request your lordship to kindly dispense with the production of the documents?
ಏನ್ ಬೇಕಾಗಲ್ವಾ?
That can be looked into, my lord. This is a
From
regular
the
first appeal.
LCR ಬಂದಿದೆಯೇನೋ?
LCR ಬಂದಿದೆ.
ಬಂದಿದೆಯಾ?
P series have been furnished, but exhibit D series original documents have been taken back by the defendants. And that is not with the copies.
ಬೇಕಾಗಲ್ವಾ
Therefore,
RF ಗೆ?
I request
Partition suit.
partition suit.
ಬೇಕಾಗಲ್ಲ.
Only RTC extracts, ಇದು mutation entries, one sale deed and one land tribunal order is there.
ಮತ್ತೆ ಬೇಕಾಗತ್ತೆ, ಅದೆಲ್ಲ ಬೇಕಾಗುತ್ತೆ. ಅವೆಲ್ಲ ರಿಲೆವೆಂಟ್ ಮಟೀರಿಯಲ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಕ್ಲೇಮ್ಸ್ ಅಲ್ಲ.
Lord, otherwise, may I request your lordship to kindly, I will deposit the amount. Mother, let the office prepare the paper books.
ಇಲ್ಲ, ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಅಷ್ಟು ಜನ ಇಲ್ಲ, ಸರಿಯಾಗಿ ಕೆಲಸನ ಮಾಡೋದು.
Earlier that was being done.
ನಿಮ್ಗೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕು ನಾವು ಕೊಡ್ತೀವಿ.
ಅಲ್ಲ
ನೀವೇ
ಟೈಮ್
ಮಾಡಿ.
ಎಷ್ಟು ಕೊಟ್ರು
ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ದಂಗೆ
ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಅದು
ಇಲ್ಲಿ ನಮ್ಮದೇ ಅಪ್ಲೈ ಮಾಡಿರಾ?
ಆ
ಎಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ಸ್ ಎಲ್ಲಿದಾವು?
exhibits D1 to D8, that is there.
ನಮ್ಮ ರೆಕಾರ್ಡ್ ನೋಡಿಬಿಟ್ಟು ಆಯ್ತು. We'll look into our own records then.
That is why I am
for
saying.
this proposal.
I submitted the documents No, my lord.
Perfect. Learned
I'm
counsel.
filing
for
a
the-
memo to that effect.
Huh?
I'm filing a
But-
memo for dispensation.
Learned counsel appearing for the appellant has filed two memos,
Only one memo.
One memo,
two
na?
copies.
one memo
Only one memo.
dated 7/11/2024, seeking an order to dispense with production of documents vide exhibits P1 to P26. Since
Alla,
the
D1
calendar can,
P1 and D1. D1 series is
But-
not with me.
P1 ಇದೆಯಾ?
D1 ಇದೆ.
D1 to D8.
Huh?
D1 to D8.
Yes, yeah.
ನೋಡಮ್ಮ,
D1
D1
to
to D8. On the ground that these documents are available in the LCR that have been called upon. First off, to this proposal, there is no objection from the other side. First off, prayer in the memo being innocuous is accepted. And production of said documents is dispensed with. All right. ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
The other paper book has already been filed.
ಅಲ್ಲ, when will you argue the matter?
Whenever your lordship.
ಅದು ಹೇಳಿ,
After-
ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕಾ ಡೇಟ್ ಕೊಡ್ತೀವಿ. 2013 ಮ್ಯಾಟರ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ನೋಡಿರಲ್ಲ ನೀವು ಲೇಟೆಸ್ಟ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ. ಬರೀ ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ತೋತಾ ಇದಾರೆ ಜಡ್ಜಿಸ್. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ನಾಟ್ ಬೀಂಗ್ ಟೇಕನ್ ಅನ್ಕೊಂಡು
Yes.
ಕಂಪ್ಲೇಂಟ್ ಹ್ಯಾಸ್ ಗಾನ್ ಟು ದಿ ಆನರಬಲ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾ.
November 20th.
ಮಾಡ್ಬೋದಾ? 20th. ಆಲ್ ರೈಟ್. ಒಂದು ಸ್ಮಾಲ್ ನೋಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಂಡೆ ಬಂದ್ಬಿಡಿ, ಸೊ ದಟ್ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ ಫಾರ್ ಅಸ್. Yes, Qureshi sir.
In this case, my lord, there is no, my lord, controversy or dispute regard to exhibits, my lord. P1 and D series and P series are the very same document. RTC
Exhibits not
mutation.
filed ಅಂತ ಮಾಡಿದಾರಲ್ಲ,
Therefore, it may be.
ಮತ್ ಬೇಕಲ್ಲ ಎಕ್ಸಿಬಿಟ್ಸ್ RFA ಇದು,
Yes, my lord.
both on law and evidence.
But the only dispute is, my lord, with regard to exhibit D1 and P1, both are same documents.
ಎಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ?
But 5 documents is there,
ಮಾಡಿ ಹಾಕ್ಬಿಡಿ. 5 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ, ಒಂದು ಸಪರೇಟ್ ಮಾಡಿ ಹಾಕಿ.
3 weeks time.
2 weeks.
2 weeks.
2 weeks for filing the paperwork comprising of exhibits in question. Final. Next, call after 3 weeks.
But
Yes. ಏನಿದು? Memo regarding cost of 2000 paid to High Court Legal Services Authority has been filed by advocate for appellant instead of Khalsa. Memo accepted. All. Second set of paperwork to be filed.
We'll furnish it during the course of the day, your lordship.
ಯಾವುದು?
Second set of paper.
ಇವತ್ತೇ ಕೊಡ್ತೀರಾ?
ಇವತ್ತು.
ಒಂದು ವಾರದಲ್ಲಿ ಹಾಕಿ, 1 week or next week ಅಂತ ಹೇಳೋಣ. Compliance by filing second set of paperwork to be done within 1 week.
Any
Fine.
date, my lords, it's a small matter.
Call after 2 weeks.
My advance is lying with him. There is a decree for refund of the advance, sir. There is specific for Mansoor. And my money is lying with him.
Lordship, the senior will appear before your lordship. to argue
Any
the
date,
matter.
your lords, let them
ನೀವು
file.
ಪ್ರಾಪರ್ಟಿನೂ ಕೊಡಲ್ಲ, ದುಡ್ಡು ಕೊಡಲ್ಲ ವಾಪಸ್ಸು. How?
55 lakhs, 20 lakhs advance paid. Trial court directed refund that advance, that's all.
Possession ಯಾರ ತೆಗಿತ್ತು?
Possession, ಅವ್ರ ಹತ್ರನೇ ಇದೆ. Property has not been, it is their
Not yet
property. ನಮ್ಗೇನ್ ಬಂದಿಲ್ಲ. ನಾನು advance ವಾಪಸ್ ಕೊಡಿ ಅಂತ direction ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ನಾವು ಇಷ್ಟು ಬೇಗನೆ ಹಾಕಿ within 1 week ಹಾಕೋಬೇಕು. Call this matter next week. Within 5 days, call this matter. ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಅಷ್ಟೇ ಕೇಸ್.
As that's all, my lords. Advance is directed to be refund, that's all. Challenging that, they have come here.
All. Okay.
Obliged.
Yes.
Fourth response, Council.
Ah.
My lord,
Nanenure.
in the 1 week time, I am seeking for, my lord, there is some paper books are ready. Some corrections are required to be done. One. Number
ಅಲ್ಲ,
two,
ಏನೋ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಅಬೇಟ್ಮೆಂಟ್
fourth respondent is dead. Fourth respondent is died.
₹300 ಕೊಟ್ಟಿಲ್ಲ.
ಅದೇ ಇವತ್ತು
ನೀವು ಬೇಗನೆ ಕೊಡಿ. ಅಲ್ಲ, ಇದನ್ನ ಕೊಟ್ಟು ಬಂದ್ರೆ ಇವ್ನ ಅಪ್ಲಿಕೇಶನ್ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬಿಡ್ಬೋದು ಅಂತ ಫೇವರೇಬಲಿ. ಅಲ್ಲಿ ಹೋಗಿ ಕೊಟ್ಟು ಬಂದ್ಬಿಡಿ, ಹೋಗಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ನಾವು. ಅದನ್ನ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ನಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇನ್ನೊಂದು fourth respondent is dead.
Huh?
Their LRs have sought for impleading my lord.
Impleading or bringing them on record?
LRs ಅಂತಲ್ಲಿ.
Appellant number 4 and 3.
3 years ಇದೆಯಲ್ಲ. So personal inconvenience ಆಗಿ
ಅದ್ ಬಿಡಿ, ನೀವ್ ಯಾರೋ ಇದ್ದಿರಲ್ಲ ಈಗ.
ಹೌದು.
ನಾವು ಪುಟ್ಟೇಗೌಡರ ಹೆಸರನ್ನು ರಿಮೂವ್ ಮಾಡಲ್ಲ. ಅದ್ ಇರ್ಬೇಕು, ನಮಗ್ ಕಾಣ್ತಾ ಇರ್ಬೇಕು ಅದು.
ಹೌದು ಸರ್. Fourth respondent.
ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡೋದು.
ಈಗ ಮಾಡ್ಕೊಂಡು ಲಘು ರಿಪೋರ್ಟ್ ಮಾಡಿ. ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ತಾ ಇದ್ವಿ. ಸರ್ವಿಸ್ ಆಗಿದೆ ಏನದು? ಸರ್ವಿಸ್ ಆಗಿದೆ. ಅಪಲೆಂಟ್.
Last one.
Counsel appearing for the submit that to pay the cost during the course of the day. The I 1 of 24, 2 of 24 and 4 of 24. 3 of 24 are fine to bring the LRs of chapter number 4. The similarly application I 4 of 24 to 6 of 24 are fine to bring the LRs of chapter number 3. Finding sufficient reasons in the affidavit filed along with these applications, the delay condoned. Delay is condoned as mentioned therein. The applications are allowed. The applicant to carry out the necessary amendment and file the amended cost rate. He should also delay is condoned and abet the applicant to file the paperwork within 2 weeks.
2 weeks. Ready? ಮಾಡಿ ಕೊಡಿ.
2 weeks.
ಅದನ್ನೇ ಹೇಳಿದ್ವಿ ನಾವು.
Please.
Right.
For the appellant in this case,
ಏನಿದೆ?
in this case, what has happened, parties are making it in the way of compromise, my lord.
ಲಾಯರ್ಗಳು ನಮಗೆ ಕೇಳುವ ಧ್ವನಿಯಲ್ಲಿ ಮಾತಾಡ್ಬೇಕು.
So parties are at the way of compromise, that settling the matters.
Ah.
And in the meantime, that possession has been handed over to the respondent. He has taken the possession of the premises. So now what I will request, list this matter in the next week. And in the meantime, execution should not proceed, because what is the purpose for proceeding the execution?
No.
That is unnecessarily going on,
My
because parties
learned
are
friend is
making the compromise.
No.
Almost ready, we'll file it before this court, matter can be settled by that week.
After long battle, now they are come forward for settle the entire issue, suit for ejectment. There is arrears of more than 30 lakhs as on today.
That is,
You are with great difficulty. you
that
have
is
taken-
my case.
One second, mister. So after
Only
long battle,
left
you are
for
with great
areas
diffi-
which I am not entitled to give. I have left the premises in 2009 itself. Suit was filed in 2011 and decree was filed in 7/4/2014 areas to pay the areas also. That is handed over. Possession is handed over. She already has taken possession.
with-
Now the matter of,
With
ಸ್ವಲ್ಪ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಿಡಿ.
I am settling the matter. My parties are settling.
with great difficulty, your lordship, the 3 months back, you have taken a possession of the premises. There are admittedly, there is arrears of 30 lakhs. Now they come forward for settle the issue, and there are several litigations. They are also file application for impeding application. If they settle the matter on Monday, your lordship, you are also agreeable. Let them settle matter. Agree.
1 week ನಲ್ಲಿ ಮಾಡಿ.
ಮಾಡ್ಲಿ ಸಮ್ ನಮಗೇನಿಲ್ಲ.
1 week ನಲ್ಲಿ ಮಾಡ್ಬೇಕು.
1 week.
ಅಲ್ಲಿ ತನಕ ಕೆಳಗಿನ ಕೋರ್ಟ್ ನಲ್ಲಿರೋ ಮ್ಯಾಟರ್ಸ್ ಅನ್ನು ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡಬೇಡಿ.
ನಾನು ಹೊರಗೆ
that is-
ನಾನು
that's
ಮಾಡೋದಿಲ್ಲ.
only request,
ಅದು ಹಂಗೆ
genuine
ನಾವೇನು-
request I am making, my lord.
ಹಾ, ಅದು ಏನು ಬೇಡ. ನಾವು ಮಾಡೋದಿಲ್ಲ, ನಾವು ಅಂಡರ್ಟೇಕ್ ಅದು. ಬಟ್ ಆದ್ರೆ ಅವರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಬೇಕು.
Counsel for the appellant submits that talks for amicable settlement are in progress, and hopefully there shall be an amicable settlement. And therefore, the proceedings pending in other courts, in the courts
Execution
below.
1797.
ಅಲ್ಲ, ತಾವು ಆ ತರ ಇಡ್ರಾದ್ರೆ ಅವರು ಕಾಂಪ್ರಮೈಸ್ಗೆ ಬರೋದಿಲ್ಲ. ನಾನು ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ.
ಹೆಂಗ್ ಮಾಡ್ಬಿಡ್ತೇವೆ ನಾವು?
ಹಾ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡ್ತೇವೆ. ಅವತ್ತು ಆಯ್ತು ಅಂದ್ರೆ ಆಯ್ತು, ಇಲ್ಲ ಹಿಯರಿಂಗ್ ಸ್ಟಾರ್ಟ್ಸ್.
ಅಲ್ಲ, ಆ ತರ ನಾನು ತೊಂದರೆ ಆಗುತ್ತೆ. ಅವ್ರು ಬರೋದಿಲ್ಲ, ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡೋದಿಲ್ಲ. ಹಾಗೆ ಇರ್ಲಿ, ನಾನು ಮಾಡೋದಿಲ್ಲ ಅಂತ ಅಂಡರ್ಟೇಕ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಷ್ಟೇ. ನಾನು ಮಾಡೋದಿಲ್ಲ.
Hopefully, there shall be an amicable settlement and therefore matter be adjourned. First topic. Learned counsel appearing for the respondent submits if talks are genuinely held as has been projected here, comma, he has no objection for adjourning the matter. First topic. Call this matter on. Which date you want?
Any date in the next week.
Pull down some date from the
Except
calendar.
Except
Calendar is
Friday,
full of dates. ಯಾವ್ದಾರ ಒಂದು date ತಗೊಳ್ಳಿ.
ಹೇಳಿ, ಯಾವ್ದು
12,
ಹೇಳಿ.
13 on,
13.
except Friday.
Finally, for reporting settlement. No further adjournment shall be granted. Granted.
In the meantime, that should be not proceeded.
ಮಾಡೋದಿಲ್ಲ
ಏನು
ಅದನ್ನ
ಮಾಡೋಣ? ಅವ್ರು ಹೇಳಿದ.
No
He
purpose.
is a
to
tall
serve.
member of the bar. He has said that, assured, yes.
Problem.
My lords, my apologies, my lord.
Yes.
21st ಹೋಗ್ಲಿಕ್ಕಿತ್ತು to collect the draft. One day there was some communication gap in my office, my lords. My lord, I would only request my lords to give me another opportunity to take the paper publication for the respondents.
Fresh paper publication to be taken in terms of order dated 1/12/2000. ಯಾವ date ಅದು?
Order dated, my lords, 28th of
7/11/24.
lords.
24. By rescheduling the dates.
Deeply.
They have not correct. Please. All.
Sorry, my lords. My apologies.
Paper books ಹಾಕೋಕಲ್ಲ.
ಹಾಕ್ತೀನಿ, my lord. 3 weeks time will be granted.
ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ಹಾಕ್ಬೇಕಾಗ್ತದೆ ಪೇಪರ್. Yes.
The appellant is not interested to pursue the matter, so I'm filing a memo for withdrawal.
This is the happiest memo for the judges. Learned counsel for the appellant has moved a memo dated so and so, comma, this day. Just memo idav.
Yeah.
The same reads as under. There is none from the other side to say anything on the said memo. First up, next paragraph. In terms of memo, this appeal is dismissed as having been withdrawn with no right to relitigate on the
Yes,
same cause of
yes.
action. Ordered accordingly. Lodi, registry to send a copy of this order to the respondents by speed post. Okay. Natraj retire ಆಗ್ತಾರ no?
Yes, I have filed no objection.
ಏನಿದೆ?
So ಇದರಲ್ಲಿ, see, the first objections I will complement. The second objections is, I have filed application for paper publication. So in that, by mistake, R16, 17 and 46 are in residing at Andhra. So I will delete that 3 names and remaining I will take the paper publication.
ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ತೀರಿ?
ಅದು ಡಿಲೀಟ್ ಮಾಡಿ ಬೇರೆ ಪೇಪರ್ ಅಲ್ಲಿ ಹಾಕೋಬೇಕಾದ್ರೆ.
Another.
ಆಂಧ್ರದಲ್ಲಿ ಅದ್ರಲ್ಲೂ.
ಮತ್ತೆ ಅದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಡಿ, ಒಂದೇ ಸರಿಗೆ ಎರಡು ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬಿಡ್ತೀವಿ. ಎರಡೇ ಡೇಕ್ ಆರ್ಡರ್ ಮಾಡಿ.
ಸರಿ. ಅದು ನಾಟ್ ಪ್ರೆಸಿಡೆಂಟ್.
IA
2022.
1 of 2024.
Because of not taking steps for 3 times, that was held.
IA 1 of 2024 duplicates IA 1 of 2022. And
Not-
therefore is disposed of as having not been pressed. All right. All after 10 days. ಅಷ್ಟ್ರಲ್ಲಿ ಹಾಕೊಳ್ಳಿ, ನೀವು ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರೆ ಜೊತೆಗೆ ಮಾಡ್ಬಿಡಿ.
Next, R11 was denied. I have
R11?
filed application, but the office objection is, so he is residing at Anekal. Date of death and
ನಮ್ಮ ಡಿಲೇ ಕೌಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬೇಕಾ, ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ, ಕೌಂಟಿಂಗ್ ಬೇಕಾಗ್ತದೆ ಅದಕ್ಕೆ.
ಡೇಟ್ ಆಫ್ ಡೆತ್ ಅದು ಬೇರೆ ಕಡೆ ಮಾಡ್ತಿದ್ದಾರೆ. Anyhow, I have filed my application.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅದ್ರ ಮೇಲೆ
ಇಲ್ಲ,
Notice
ಇಲ್ಲ.
ಹೋಗ್ಲಿ ಅವರು
no,
ಯಾವ
ಅದು
ಡೇಟ್ ಆಫ್ ಡೆತ್ ಅಂತ ಹೇಳಿರನ
ಅದರಲ್ಲಿ ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ ಸುಮ್ಮನೆ.
ಮತ್ ಗೊತ್ತಿಲ್ಲಂಗೆ ಹೆಂಗ ಯಾವ್ದಾರ ಒಂದ್ ಡೇಟ್
ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಶರ ಬಂದಿದೆ.
ಶರ ಬಂದ್ರೆ ಮುಗಿಯಲ್ಲ.
ಶರ ಬಂದಿದೆ ಅದಕ್ಕೋಸ್ಕರ, ಬಟ್ ಇಟ್ ಈಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಟು ಸರ್ಟೈನ್.
But it's very difficult for us also
No,
to entertain
my
an
client has
application
went to-
which is not rightly dressed.
My client has went to several times, but
ಕೇಳ್ಕೊಂಡು
notice ಹೋಗ್ಲಿ ಸ್ವಾಮಿ, let them come.
ಅಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಲಿಕ್ಕೂ ಸಹಿತ ಸರ್ವಾಗ
Yes, sir.
ಯಾವ್ದಾರ ಒಂದ್ ಡೇಟ್ ಹೇಳಿದ್ರೆ ಸಾಕು, ಇಂಥ ದಿವಸ ಆಗಿದೆ.
ಇಲ್ಲ, ಅವ್ರು ಮತ್ತೆ ಇದು ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್.
ತಪ್ಪು ಅಂತ ಹೇಳಕ್ ನೀವು ಡೇಟಾ ಹೇಳಿಲ್ಲ, ಅದಕ್ಕೆ ಅದು ಒಂದು ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹೇಳಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆನ್ ಅಪ್ಲಿಕೇಶನ್ ನಂಬರ್ 21 ಕೀಪಿಂಗ್ ಓಪನ್ ದಿ ಆಫೀಸ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
ಏನು
R11 and 12 are one and the same. I have delete the name of 12.
memo seeks deletion of respondent number
R12.
12
Oh.
since
R11
12
is
is
also.
duplication of 11.
Yes, ma'am.
First, prayer in the memo is accepted. To make a note beside the cost title. Okay. Steps in respect of deceased or three
I will take my letter.
to be taken within 2 weeks.
Yes, ma'am.
First. All.
The last, the respondent has to file second set.
ಯಾವುದು
The last though, ನಮಗೂ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ. Statement of objections I have filed.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಬಿ ಕಂಪ್ಲೈಡ್ ವಿತ್ ಅದು ಯಾರು ಇರ್ತಾರೆ ಅವರೇ
ಹ್ಮ್.
within 2 weeks.
Additional documents ಹಾಕಿದ್ದೀನಿ, bulky documents. The suit is for a partition and separate person.
ಇದು ತೋಳಿ ಸ್ಟೆಪ್ಸ್ ಎಲ್ಲ ತೋಳಿ ನೋಡಿ.
ಹಾ.
ನೆಕ್ಸ್ಟ್ ಹಾ
One week's time. So my mistake.
1 week for doing the needful.
Right. Sorry.
Connected appeal, my lord, sir.
ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಆಗಿಲ್ವಾ?
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. paper
ಮಾಡಿದ್ರಾ?
ಮಾಡಿಲ್ಲ.
In the connected matter.
ಹಾ
Connected matter, my lords, already paper books have been filed.
ಹಾ
So it may be. suit
may
for
not be
parties
necessary.
and common-
ಮಾಡ್ಬೋದಾ? Both the sides submit that in the connected matter ಯಾವ್ದದು?
765 of 17, my lord.
Huh?
765 of 17, serial number 9.1.
In connected matter that is in RFA 765 2017 arising from the very same judgment
Same
and
judgment.
decree, paper books have been filed and therefore filing of the same in companion RFA 1555 of 2017 be dispensed with. First, we agree with this. Okay.
My lords, I have filed an application for early hearing, my lords. The date may be.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಮಗೂ ಕೇಳ್ಬೇಕು, ಕೋರ್ಟ್ನಲ್ಲಿ
Yes.
ಕೂತವ್ರಿಗೂ ಕೇಳ್ಬೇಕು.
My lords, I have filed an application for early hearing, my lords.
ಅಲ್ಲಿ ಯಾವ ಡೇಟ್ ಬೇಕು?
My lords, any date in next week or subsequent week, my lords.
Next week
I'm ready.
difficult, but week after next. 2017 ಇದು. The
There's a
second
short-
week of January 2025. Okay. 13th ಓದ್ತಾ ಇದೆ ಇವರು. 13 ಎಲ್ಲ ಹಂಗೆ ಇದೆ.
Short question is involved, my lords.
ಎಲ್ಲದರಲ್ಲೂ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಇದೆ. ಯಾವ ದೊಡ್ಡ ಕ್ವಶನ್ ಇರುದೇ ಇಲ್ಲ. ಎನ್ ಕೇಶವಾನಂದ ಭಾರತಿ ಅಲ್ಲ ಎಂತದ. ತಳ್ಳಿ.
Sorry.
Next. Short question. Depending upon brain size of the questioner and the answer person who has to answer. Yes.
Appear for petitioner in this matter.
ಮುಕ್ಕಣ್ಣಪ್ಪ.
My lord, R125, my lord, already respond, Baswaraj has filed.
5 acknowledgement ವಾಪಸ್ ಬಂದಿಲ್ವಾ? ಬಂದಿಲ್ಲ. ಅದನ್ನ ಅಬ್ಸರ್ವ್ಡ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ಬಿಟ್ಲ. ಅಲ್ಲ R2, R4, R6 ಮಾಡೋಣಂತೆ. ಬಟ್ ಅದು R1, R3, R5 ಯಾರು ಅವರು? ಬಡಿ.
My lord, my respectful submission is this, my lord. Already Wakalat has been filed before the Samba court.
ಯಾರಿಗೆ?
1 to 5, my lord.
1 to 5, my lordship.
ಯಾರು ಅಪಿಯರ್? ನೀವು ಅಪಿಯರ್?
I am for the respondent.
Three. So and so appears for respond numbers 1 to 5. 1 to 5. ಅಲ್ಲೇ
My lord,
ಅಲ್ಲಿ-
regarding R6, my lord,
6 ಗೆ ಏನಾರ ಮಾಡಿ.
I take steps, my lord.
Steps to be taken in respect of R6 by way of emergent notice. ಅದು rectification of memo of appearance filed by Sri Basavaraja.
Everything.
All right, Basavaraja, ನೋಡಿ.
Even for the
Objection overruled. Okay.
objections is also.
All right, we have said that. Yes, next.
Objection statement also corrected.
I am for the R1 to R1 to R5. Other objection, all objections are overruled. Okay. You collect ಮಾಡ್ಕೊಂಡ್ರಾ?
ಮಾಡ್ಕೊಂಡು.
All right. Call this matter. And ready, service ಆಗ್ ಬರ್ಲಿ. Post this matter immediately after service on R6. Service of notice on R6. Next.
ಮದ್ದು.
Petition, my lord.
The
The translation of Kannada to English.
Kannada ಏನ್ ಬೇಕಿಲ್ಲ.
Against the final order,
Translation ಏನ್ ಬೇಕಿಲ್ಲ.
against the final order.
Ah.
The
Appeal
is
ಇದೆಯೇನು?
Please, my lord.
ಕೊಡಿ ಅದು.
17A.
ಮೊನ್ನೆ ನೋಡ್ಲಿಕ್ಕೆ ಹೇಳ್ತಲ್ಲ ಕೊಡಿ.
17A.
ಯಾವ್ದು ಸೆಕ್ಷನ್?
17A.
ಬ್ರದರ್ ನಾವು ಏನ್ರ ಹೇಳ್ದಾಗ ತಪ್ಪು ತಿಳ್ಕೊಬಾರ್ದು, ಅಫೆಂಡ್ ಆಗ್ಬಾರ್ದು.
Sir.
ನಮ್ಮ ಉದ್ದೇಶ ನೀವು ಎಲ್ಲರೂ ಜೊತೆಗೆ ಕಲಿಯೋದಿದೆ.
Please.
ಜೊತೆ ಕಲಿಬೇಕು ನಾವು. ಎಲ್ಲದಕ್ಕೂ ಅಫೆಂಡ್ ಆಗ್ಬಿಟ್ರೆ ನಾವು ಹೆಂಗ್ ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? ಪ್ಲೀಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ನಾವು. ನಾವೇನು ಇಲ್ವಿಲ್ಲ ಏನು ಮನಸ್ಸಿನಾಗ ಇಟ್ಕೊಳೋದಿಲ್ಲ.
17A. Amendment to Rule 20.
ಕೊಡಿ.
Amendment Act.
ಅಪೀಲ್ ಇದ್ರೆ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾಗ್ತದೆ, ಅದಕ್ಕೆ ಬರಲ್ಲ. ಕೊಡಿ. ಇಲ್ಲೇನು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನ್ರ ಇದೆ ಏನೋ?
ಇಲ್ಲ.
ಇಲ್ಲ. ನೋಟಿಸ್ ಆಗಿ ಯಾವ್ದು ಬ್ರದರ್?
17A book ಕೊಟ್ಟು.
70
ಕೊಟ್ಟಿದ್ದೀರಾ?
17.
17A
A.
1, my lord.
ಇದೇನು ಆಕ್ಟ್ ರೂಲ್ಸ್?
ಇದು Amendment Act 2020.
ಆಕ್ಟಾ?
Please, my lord.
2020 amendment.
Please.
With effect from which date?
From date of 30, from 19th day of October 2020.
19th day of 2020. ಇದರ ಆರ್ಡರ್ ಯಾವಾಗ ಆಗಿದೆ?
Order before that.
5/8/2019 ಅದು.
Please.
Whether right of appeal is is a substantive right. Retrospective ಆಗಲ್ಲ ಅದು.
Please, my.
ಹಂಗಾಗಿ petition is maintainable ಆಗ್ತದೆ. Right to appeal is held by the apex court as a substantive right. So where the appeal, right of appeal is provided on appeal against any final order with a special court determining the civil liability of the party shall lie to the High Court. If the High Court is satisfied, the case involves a substantial question of law. How such provisions are interpreted? There is one Kerala High Court judgment that you have to bring. Justice Potti said similar sections are retrospective in operation and hold madidar. A judgment to money Kerala. All right, you have to bring that because you want to non-suit him. In appeal hogri in parad hakana.
2019 order.
Because here substantial question of law is not involved.
ಆವಾಗ ಅಪೀಲ್ ಹಾಕಕ್ ಬರಲ್ಲ ಅವರಿಗೆ. unrendered petition maintain ಆಗ್ತದೆ ನಿಮ್ಮ. Both the sides submit, both the sides agree that a statutory appeal is provided while amended provisions of section 17 capital A of the Karnataka Land Grabbing Prohibition Act 2011. First, if that be so, this petition cannot be maintained. And accordingly requires to be disposed of, reserving liberty to the petitioner to avail the remedy of appeal, keeping open all contentions. First off, the time spent during the pendency of this appeal is liable to be discounted while computing the period of limitation prescribed for the contemplated appeal, needs hardly to be stated. First, ordered accordingly and writ petition is disposed of. Registry to return the certified copy, impugned order after retaining Xerox copy of the same in the file. Okay. He says, in such cases, the retrospective of that is marked. Yes,
My lord, the office objections are regarding the translated copies, my lord.
translated copy. Dispensed with.
Section 12, my lord. As far as the merits of this, my lord, My lord, the respondent number one DGO.
Huh?
The respondent number one is a DGO, my lord. He was working as a commercial tax officer. And a complaint was given to the Karnataka Lokayukta that he has been collecting huge,
60,000 rupees, 6 lakh.
yes.
Huh.
He's collecting and that he's appropriating that to himself. Subsequently, after investigation, my lord, it is revealed that the respondent number one DGO has secured several immovable properties without obtaining the permission from the competent authority. That being the situation, my lord, a report was forwarded to.
ಅದನ್ನೇನು ಕ್ವಾಶ್ ಮಾಡ್ಯಾರನ ಅವರು?
ಹೌದು. The entrustment order
Issue
as well as.
emergent notice. ನೀವು ಬೇರೆ ಕೇಸ್ನಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲಲ್ಲ, ನಾವು ನೋಟಿಸ್ ಮಾಡೋದಲ್ಲ.
ಅಲ್ಲ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ರೆಡ್ಡಿ ಮೇಲೆ.
ಇವರಲ್ಲ. ಸಾರಿ. Okay.
Lord,
Issue.
stay in this.
Issue emergent notice. Interim order as prayed for till next date. Interim
Yes.
order ಕೇಳಿದ್ರು.
ಹೌದು,
ಕೇಳುವಾ?
ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಬೇಕು ಸ್ವಾಮಿ.
Till next
Obliged.
date. Okay. Learned AGA for R2. Accepts note. He is requested to accept notice for R2. Okay. Please. Steps ಏನೇನೋ ತಗೋಬೇಕಲ್ಲ ಅದರಲ್ಲಿ.
Non-furnishing of PF, my lord, I'm filing dispensation memo.
The unserved respondents are the ones who have been denied with the relief by the tribunal. So they are not before the court challenging that order.
They are not before.
Yes. The caveat respondents are the ones who have been favored, my lords, by the applicant for the relief.
Okay.
1 to 8.
Notice. Notice ಅಲ್ಲ, ನೀವು ರಿಮೂವ್ ಮಾಡಿದ್ರೆ ಮಾಡ್ತೀವಿ. As long as they are on the cost title, you have to take steps. If you agree to delete, you may delete them. Delete ಮಾಡೋಣ?
Yes, ma'am.
Learned AGA submits and learned senior advocate appearing for the contesting respondents does not also agrees that the respondent numbers
1 to 8.
uh,
1 to 8, my lord.
1 to 8
11, 12.
be deleted from the array of parties since they have not been denied relief at the hands of the tribunal.
They have been denied the relief.
They have been denied relief
Dismissed it.
at the hands of
The tribunal.
tribunal. Tribunal. Full stop. Permission accorded. Petitioner to amend the cost title.
My lord, 1 to 8,
Huh.
11, 12,
1
17,
to 8 to 11, 12, 17 to 44,
28.
To
my lord.
28.
I have corrected, my lord.
17 to 28.
Yes.
1 to 8, no, ma. 1 to 8, 11,
12,
12, 17 to 28.
28.
Or delete, madam.
Obliged.
Okay.
May I request, my lords, that lords, we have been denied the benefit of change of cadre, lords,
The
with
meantime,
effect from
parties have agreed not to process the.
9/3/2020, my lords.
No, ಈಗ entry ಮಾಡ್ರಿ ಇದೆ ಅಲ್ಲ.
Lords, interim order is
ಇವ್ರಿಗೆ
granted.
entry ಮಾಡಿರ್ದೆ.
Lords,
Process
yes.
ಮಾಡಬಾರ್ದು ಅಂತ.
Lords, this is the reason, my lords. We have been denied the benefit since 4 years. Our juniors have already been provided for the change of cadre. Now the KACT has directed that our consideration of our application should be retrospectively with effect from 9/3/2020. The very, very short issue is this, my lords. There is a provision for change of cadre.
Are you ready in the matter?
No, my lord. Age is.
Not ready. AG will come.
Yes, ma'am.
Very short point ಇದೆ.
Next week.
Retrospective promotion.
Lords,
Change
short
of
point-
header.
You have given promotion to the
the-
other juniors.
Yes, my lords, it is something like this, my lords. There's 2 sentences. There is a provision for the change of cadre from typist to second division assistant and vice versa, subject to fulfillment of certain conditions. Now, how and on what basis a person becomes eligible is provided for. There is no difficulty. Now, if there are 10 posts, if 20 applicants file the applications, what should be the criteria for consideration of their applications is the only short question. Rule 3, which provides for the procedure, says, as soon as the application is filed, it will have to be considered and orders has to be passed. We were the earliest applicants. The private respondents who are actually given the change of cadre were the later applicants. The tribunal holds that since we were the earlier applicants,
See,
the
this is a
that is
early
all the
bird
question.
catches the prey is enacted in that rule 3.
Yes,
That's the only point.
that is the only point.
ಏನ್ ಇಷ್ಟ ಇದೆ ಮತ್ತೆ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಒಂದು
ಅಲ್ಲಿ ಪಾಸ್
ಪಾಸು ಇವತ್ತಾಗ್ತದ ಆಯ್ತು ಕರ್ಕೊಂಡ್
ಯಾಕಂದ್ರೆ ಮಂಡೇ ಮೇಲೆ ಮಂಡೇ
ಅಲ್ಲ ಇವತ್ತು ಹೆಚ್ಚು ಕೆಲಸನೂ ಇಲ್ಲ ನಮ್ಗೆ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ ನೋಡೋಣ ಅಷ್ಟೇ ಇತ್ತು ಅಂದ್ರೆ ಮಾಡಿ ಮುಗಿಸಿ
That's the only point.
ಪಾಸು
Please.
ಎಸ್ ಬಸವರಾಜ
Yes, my lordship. My lordship, I have already filed that is the delay in condonation, delay for the bringing the LRC is already condoned, already accepted. Accordingly, I filed the amended cast title also during 2022 only.
ಆಗಿದೆಯಾ
Thereafter, I filed
ಅದನ್ನ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತಾರಲ್ಲ ಆಲ್ರೆಡಿ
2022 only.
IA 1 of 2021 supported by affidavit seeks condonation of delay proved in filing the accompanying application in IA number 2 of 2021 for bringing the LRs of deceased respondent. Full stop. The second application is also supported by an affidavit. Full stop. Plausible explanation having offered, delay of how many days?
My lordship.
Yes, this is a delay.
My lord, delay, actually, my lordship, when we sent the notice, we came,
Tam prashne uttara kodi.
my lordship, hardly 1 month or 20 days, my lordship,
Yes, this is the
20 days.
ಮಾಡಿಲ್ಲ ಡೇಟ್ ಆಫ್ ಡೆತ್ ಯಾವಾಗ ಆಗ್ತದೆ 21/21 ಮರಣದ ಸ್ಥಳ ಅಪ್ಲಿಕೇಶನ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತೀನಿ ದ ಶಾರ್ಟ್ ಡಿಲೇ ಏನ್ ಬರ್ದೇಮ್ಮ ಲಾಸ್ಟ್ ಲೈನ್ ಏನ್ ಬರ್ದೆ offered, delay proved in filing the LR application is condoned.
Yes.
Full stop. For the reason stated in the application in IA number
One.
2 of 2021, supported by the affidavit, the said application is also favored and LRs of deceased respondent are permitted to, ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
What, 6 members, my lordship.
Are permitted to be brought on record to represent the estate of deceased. Petitioner to amend the cast title.
My lordship, that is already over, my lordship. Last time it was permitted during 2022 itself. I filed the amended cast title. I have already filed the amended cast title.
First, ಅಲ್ಲಿ amend ಇದೆಯಲ್ಲ amended cast title.
And
filed by
also,
petitioner
2 times notice has been sent to the LRs as per the orders of this court.
accepted.
Now, next is the arguments with the LRs.
ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ.
Date, my lordship.
ಆರ್ಗ್ಯೂ ಮಾಡಿಬಿಡಿ ಏನಿದೆ ಮತ್ತೆ ಸರ್ವಿಸ್ ಆಗಿದೆ ಎಲ್ಲ ಆಗಿದೆ ಅಲ್ಲ ಯಾವ ಡೇಟ್
Short date, my lordship.
ಅಲ್ಲಿ ಒಂದು ಇಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಬೇಕು ಅಮೆಂಡೆಡ್ ಇದನ್ನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡೀವಿ ಈಗ ಸ್ಟಿಲ್ ಯು ಹ್ಯಾವ್ ಟು ಅಮೆಂಡ್ ರೂಲ್ಸ್ ಇಸ್ ದಟ್ ವೇ
Oh, yes, my
ಮಾಡಿಕೊಡಿ
lordship.
ಮಾಡಿಕೊಡಿ ಕೊಡಿ ಅಲ್ಲೇ petitioner to amend the cost title. Yes. All after 3 weeks as requested. Yes, Dhanappa.
Assistant Agriculture Officers retired on 2009, 30th for 2009. Before attending the superannuation period, he was voluntarily retired.
VRS ಕೊಟ್ರಾ?
VRS ಕೊಟ್ರು ಎಲ್ಲ ಕೊಟ್ರು ಸ್ವಾಮಿ.
ಹಾ.
ಬಟ್ ಅವರು ಸೂಪರ್ನೇಷನ್ ಪೀರಿಯಡ್ ಏನಪ್ಪ ಅಂದ್ರೆ 2013 ಆಗ್ಬೇಕಾಗಿತ್ತು, 2009 ಆದ್ರು. ಆ ಪೀರಿಯಡ್ ಅನ್ನು ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಪೆನ್ಷನ್ ಅಲ್ಲಿ ಏನಪ್ಪ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಕೌಂಟ್ ಮಾಡ್ಬೇಕಂತ ಒಂದು ಜಿಒ ಇದೆ 252 KCSR ಪ್ರಕಾರ. ಅದು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದೀನಿ ಸರ್. ಪೇಜ್ ನಂಬರ್ 20 ಅಪ್ಲಿಕೇಶನ್ ಇಂಟರ್ನೆಟ್ ಪೇಜ್ ನಂಬರ್ 2 ಅಪ್ಲಿಕೇಶನ್
285 2V.
285 ಅದೇ ಸ್ವಾಮಿ 2V. ಈ ಯೋಜನೆಯ ಮೇರೆಗೆ ನಿವೃತ್ತಿ ಹೊಂದುವ ಸರ್ಕಾರಿ ನೌಕರನಿಗೆ ವಿಶ್ರಾಂತಿ ವೇತನ ಉಪದಾನವನ್ನು ನೀಡುವಾಗ ಅವನು ವಾಸ್ತವವಾಗಿ ಸಲ್ಲಿಸಿದ ಅರ್ಹತಾದಾಯಕ ಸೇವೆಯ ಜೊತೆಗೆ 5 ವರ್ಷಗಳವರೆಗಿನ ಆಧಿಕ್ಯವನ್ನು ವೇಟೇಜ್ ನೀಡತಕ್ಕದ್ದು. ಆದಾಗ್ಯೂ ಹಾಗೆ ನೀಡಿದ ಆಧಿಕ್ಯವು ಸೇರಿದ ನಂತರ ಒಟ್ಟು ಅರ್ಹತಾದಾಯಕ ಸೇವೆಯು ಯಾವುದೇ ಸಂದರ್ಭದಾಗಲಿ
ಅವನು ನಿವೃತ್ತಿ ವಯಸ್ಸನ್ನು ಹೊಂದಿ ನಿವೃತ್ತಿ ಹೊಂದಿದ್ದರೆ ಅವನಿಗೆ ಸಿಗುತ್ತಿದ್ದ ಅರ್ಹತಾದಕ ಸೇವೆಗಿಂತ ಅಧಿಕವಾಗುತ್ತಲ್ಲ ಎಂಬ ಷರತ್ತಿಗೆ ಒಳಪಡತಕ್ಕದ್ದು. ಎರಡನೇದು ಕೂಡ ಅದನ್ನೇ ಹೇಳುತ್ತೆ ಸ್ವಾಮಿ.
ಅವ್ರೇನು ಹೆಂಗೆ ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಯಾರು?
ವಾಲಂಟರಿ 2009 ಮಾಡಿದ್ರು, ಆ 5 years ವೇಟ್ ಬರಲ್ಲ, 4 years 12 months
Take
ಬರುತ್ತೆ
notice.
ಅಷ್ಟೇ ಸರ್.
1953 is his date of birth, my lord.
That's all right.
Allah,
Just it
may I-
requires consideration, because in one matter,
Yes, ma'am.
roughly we have agreed with similar submission in Dharwad,
Yes, ma'am.
roughly.
Yes, ma'am.
So we have to look into that. That was argued by Tata Bhangi.
Please.
ಅದೊಂದು ಕಾಪಿ ತಕ್ಷಣಿ. ನೀವು ತಕ್ಷಣ ತೊಂಬನ್ನಿ.
There is one circular, my lord, if my lords kindly permit me. So. First page.
ಆಯ್ತು, ಲರ್ನೆಡ್ ಇದಾಗ ನೋಟಿಸ್ ಆಗಿದ್ದೇನೆ ಇದರಲ್ಲಿ.
ಆಗಿದೆ.
ಲರ್ನೆಡ್
Yes.
AG is requested to accept notice for respondents.
My lord, this,
Sir. ನೀವು ಮೆಮೊ ಹಾಕಿ ಕೊಡ್ಬೇಕು, ಹಿಂಗ್ ಕೊಟ್ಟರೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಲ್ಲಿ ಏನೋ we
Lord,
write some strict
last minute
resignation.
I could get this, my lord, I'm sorry.
Don't
I'll
say all that. The government advocate
I
is
will-
on
I will.
par with rest of the
Please,
advocates,
my lord. I'm
maybe
sorry.
little less. Yes. Don't have any special status.
Short
ಎಲ್ಲ
date.
ಬೇರೆ advocates ಹಂಗೆ
Any
ಇರ್ತದೆ.
short date, any short.
ಬರ್ರಿ, the
any short
second
date.
week of January 2024. Yes. ಅವ್ರಿಗೆ ಎಲ್ಲ ಲಾಯರ್ಸ್ ಏನು ಅಪ್ಲೈ ಆಗ್ತದೆ, ನಿಮಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
Please, my lord.
ನಿಮ್ಗೆ ಇನ್ನೂ ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
ಇಲ್ಲ, ಇಲ್ಲ, I
ಎಲ್ಲ
understand.
ಮಾಡ್ಬಾರ್ದು. No special
My
status.
lord, I could get this from finance department at 10:15. First
Don't
page
produce it.
ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವರು. I
If that
have
is so,
secured.
don't produce.
I beg your pardon.
That's all.
Henceforth it will be taken.
No special status for government.
it will be
advocates.
taken
We
care
know
of.
what kind of, will not say more than that.
Please, ma'am.
On 15 days, sir.
Huh?
On 15 days.
Work next.
After 15 days.
Next.
I am for the petitioner in this case, my lord.
Huh?
I am for petitioner in this case, my lord. Serial number 16, my lord.
16, yes.
Please, my lord. Being aggrieved by the dismissal of the application.
ನೀವು ಸ್ವಲ್ಪ ಹಿಂದ್ಗಡೆ ಸರ್ಕೊಳ್ಳಿ, ಅಂದ್ರೆ ನಿಮ್ ಮುಖ ನೋಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ನಮಗೆ.
Please, my lord. Being aggrieved by the dismissal of the application filed by the petitioner herein before the KSAT, petitioner is before this court, my lord. Petitioner has challenged the order of penalty imposed by the first respondent, my lord.
ಏನ್ ಚಾರ್ಜ್ ಏನು?
Lord, the charges are that petitioner being a assistant executive engineer failed to prevent unauthorized construction and failed to prevent the collection of unauthorized fees by the constructed toilets and Samudaya Bhavana ಅಂತ ಅನ್ನೋದು allegation ಇತ್ತು ಸ್ವಾಮಿ.
ಮತ್ತೆ ಅನ್ಅಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗುವಾಗ ಸುಮ್ ಕುತ್ಕೊಂಡ್ರೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು?
My lords, that construction itself is not unauthorized, my lords.
Not unauthorized.
Not unauthorized, my lords.
Who decided that it is unauthorized construction?
The person who has attended the inquiry as DGO number 3 has submitted a report to the inquiry officer and the Lokayukta stating that he has taken action to demolish
Where
the
is the-
unauthorized construction.
Madam,
My
where
lord.
is prima facie material to show that the structure is an unauthorized construction? ಎಲ್ಲಿದೆ prima facie material? ಅವ್ನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಅಂದಾಗನೇ ಇವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಬಿಟ್ರೆ where the employee should go. There is such finding, prima facie finding ಬೇಕಾ? ಇದು unauthorized construction. During your tenure it happened. You allowed it to happen.
Please.
We can understand.
The
Where is that aspect is not addressed by the tribunal at all.
order passed by the competent authorities in page 127.
15,
127, my lord.
127.
Last para, my lord. 127.
ಯಾರು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿದ್ನ?
My lord,
Where is the finding? That
finding, my lord, last paragraph, my lord. ಆದರೆ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತ, last paragraph at page 127, my lord.
Lords, it is in white page number 176, my lords. After translated copies,
176,
176, my lords.
ಇಲ್ಲ, ನಮ್ದ್ರಲ್ಲಿ ಪೇಜಿನೇಷನ್ನೇ ಮಾಡ್ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು.
ಅರೆ ಬ್ರದರ್ ಪೇಜಿನೇಷನ್ ಮಾಡಿ ಕೊಡಲ್ವಾ ಅವರಿಗೆ?
ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ, I'm sorry.
ಇಲ್ಲ, ಇಲ್ಲ.
ಅವರು ಹಂಗೆ ಕೊಟ್ರೆ ನಿಮ್ಗೆ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ?
I'm sorry, my lords.
ಎಲ್ಲಿ who decided prima facie that it's an unauthorized structure? ಎಲ್ಲಿದೆ finding?
There is no finding.
ಫಸ್ಟ್ ಆ ಫೈಂಡಿಂಗ್ ಬೇಕು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದಾರೆ ತಿಲಾರಿ ಸಾಹೇಬ್ರು. ಅವಾಗ ಮುಂದೆ ಏನಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. Where is the order? That competent authority has to say, this is an unauthorized structure. Only then action can be taken. How that matter is addressed by that point is not considered by the tribunal. Argue ಮಾಡಿರಲ್ಲ ಎಂತದಿಲ್ಲ. ಎಲ್ಲ substandard arguments. ಹಿಂಗಾಗಿ ಇಲ್ಲೆಲ್ಲ ಬಂದು ಬೀಳ್ತಾವು. ಇಲ್ಲೂ substandard argument. ಇಲ್ಲೇಂ ಭಾಳ ಡಿಫರೆನ್ಸ್ ಆಗಲ್ಲ.
Charges are
Issue emergent notice. Learned AG is requested to accept notice for first respondent.
R1.
BBMP ಯಾರು?
BBMP Pawan Kumar.
The Pawan Kumar, learned panel counsel is requested to accept notice for second. And learned panel counsel Shri Lokayukta ಯಾರು?
Arbatti Melan.
ಎಂತ ಅರ್ಬಟ್ಟಿ ಅವರು? Venkatesh Arbatti is requested to accept notice for respondent number 3. Petitioner to serve copies of the petition along with paginated copy of the petition along with all the documents
Right, my lord.
on the advocates, on all the advocate, on EGA, on panel counsel, panel advocates as well. Within 1 week and file acknowledgement in the registry within next 1 week, failing which petition stands rejected.
I have sought for interim prayer, my lords.
ಅದ್ ಮೊದ್ಲಿಗೆ ಪೇಜಿನೇಷನ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ತಾನೆ ನಿಮ್ಗೆ KIT-ಯಲ್ಲಿ?
ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. No, my lord, sorry, my lord.
KIT-ಯಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತೀರಿ, ಮತ್ತೆ ಇಲ್ಲಿ ಹೆಂಗ್ ಕೊಡೋದು? ನೋಡ್. Yes.
The respondent one, my lord. Lord.
Has to say. Yes, Sanjeev.
My lord, in this matter, the respondent, my lord, was working as assistant town planning director in the corporation, my lord. Fraudulent document without any amalgamation of sites. He has passed an order and the town plan has been approved. As against that, my lord, page 56, only one paragraph, page 56. He was sent back to his parent department.
56.
Yeah, like last order. ಹೇಳ್ಕೊಂಡು ಅಂಶ ಪರಿಸ್ಥಿತಿ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ಸಲ್ಲಿಸಿರುವುದು ದಾಖಲಾತಿ ಸಮರ್ಪವಾಗಿರುವುದು ಅಥವಾ ನಕಲು ದಾಖಲೆ ಆಗಿರುವುದೆಂದು ದೃಢಪಡಿಸಿಕೊಂಡು ಅನಂತರ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ನಿಯಮವನ್ನು ಕ್ಷೇಮ ಜರುಗಿಸುವುದು. On this charge, my lord, he was sent back to his parent department.
Yes.
That was challenged before the KIT, my lord. KIT, my lord, passes an ex parte order staying this order.
What's your right to be,
My lord.
in a foreign department? You belong to which department?
BBMP. A complaint against me has been filed, my lord, saying that the plan approval has been forged and fake document has been produced, but that's not the case, my lord.
I will assume that what you say is true.
And the same.
What is your right to cling on to a foreign department to which you are not holding lien?
No, the thing is that, my lord, we have not done any fraudulent act, anything.
They don't want you.
No, on that basis, my lord, they filed an application saying that the act has not done in any wrongful manner and the complaint has been withdrawn, on the basis of which I have been posted on 9/9, my lord.
But they don't want you. What is deputation? Deputation, Justice Desai said in Gujarat judgment, is a tripartite arrangement. Lender, borrower, employee. And if any one of them does not want, it collapses. They are saying, we don't want you. The whatever charges are may not be true at all.
Yes, my lord.
They don't want you. Will you withdraw the allegations?
No, my lord.
You want to retain the allegations?
My lord, in fact, the order was made in view of the order passed by the KIT. Now he's been posted because of the order, my lord. It's an ex parte order.
After the order, my lord, the complaint has been withdrawn because of that reason that the allegation which has been made was not proved.
The owner,
Another thing, my lord.
the owner herself says that
One
fraudulent
another
document
thing, my
has
lord.
been produced.
Main thing, the one thing was, my lord, there was no fraudulent act of the petitioner, the respondent, and the same has been considered. Finally, that on the words of retirement, my lord. Yes.
What is your right to continue on a foreign
The
department?
only thing is, my lord, he is on the verge of retirement. Only 4 months left for the retirement.
Parent department, all pension settle.
After consideration of this withdrawal, the department themselves has considered.
No, that is
The
also
depart-
public works department.
Kindly, on production of document, page number 4, my lord, on 9924, on consideration of all these things, I have been posted. One,
Petition allowed, the impugned order is set at naught in view of apex court decision in science. Follow Marco. Next. Science or peers for science. Next. Late. Gujarat judgment apex court refer ಮಾಡಿದ್ವಲ್ಲ ಯಾವುದೋ ಮೊನ್ನೆ ಒಂದು ಅದನ್ನ ಕೋಟ್ ಮಾಡಿ. Yes. ಹಾ.
For the petitioner, my lord.
Yes, Madhukar.
I'm challenging an order. I sought for remission of the proceedings before the land being court to the trial court, my lord. That is the city
Remission
civil
on
court.
board, remitting.
Remitting, my lord.
You
And
know,
that particular application came to be rejected, my lord. And the reason.
why you wanted that
The-
matter to be remitted to?
There was a grant order which was passed. By virtue of that particular grant order, I occupied that particular premises. If I occupied the premises on the virtue of a grant order, my lord, I am not a land grabber. If at the initial stage itself, I occupied the premises and I am an encroacher, then I become a land grabber within the definition of Land Grabbing Act.
Your Justice Arvind Kumar
Yes, my lord.
judgment
Yes,
ಏನಂತ
my lord.
hold ಮಾಡಿದ್ರು?
Yes, on last date of hearing, I had given that particular judgment, my lord. It is the 26th November 2019, that particular. Paragraph, my lord, 17, my lord.
ಇದೇನಾ? ಕೊಡಿ.
Para 17, my lord, the questions has been framed, my lord, and then it has been answered. Referring to section 20 of the, sorry, my lord, I don't have the copy, my lord.
You don't have. All right, ನೀವು ತೊಗೊಳ್ಳಿ. ನಾವು ಇಲ್ಲಿ ಓದ್ತೇವೆ. ಒಂದು ಇದೆ ಕಾಪಿ ನಮ್ಮಲ್ಲಿ.
Para 17, my lord, the questions have been formulated, my lord. The third question would be relevant, my lord, and that has been answered. At para number 26, page number 21, my lord, the discussion with reference to those questions starts, my lord.
This matter did not go to the Supreme Court.
My lord, initially I filed a suit before the civil court, my lord.
No.
Yes,
This decision
yes, my lord. Yes,
did
my lord.
not go to the Supreme Court.
It did not go to the civil court. Sorry, my lord. Suit was restored to the civil court, my lord. Suit was restored to the civil court.
Was restored to the civil court.
Yes, my lord. Initially, suit in this particular case, my lord, that was my lords are considering that particular case. The initially suit was instituted before the civil court.
Correct.
Then, my lord, it was under section 20. It was transferred to the land grabbing court.
Correct.
And then, my lord, and that particular question, that particular transfer was challenged before the court, my lord. And at that point of time, my lord, the court was considered whether this court has considered whether the civil court is the appropriate forum to decide or it is the land grabbing court. Then, my lord, the question was whether how he entered the property. If he had entered the property.
Gained entry lawfully.
Yes, my lord.
Then
It is not an act of land grabbing.
What do you say?
To one set copy, my lord.
Notice.
Yes.
First time ಬಂದಿದೇನೋ?
My lord, last time it had come, but I will provide the copy, my lord. I will just photocopy it and give it to the.
Notice ಆಗಿಲ್ಲ ಇನ್ನು. Learned AG is requested to accept notice for now respondents.
Four respondents, my lord.
1, 2, 3, 4. ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರು?
The complaint was not filed, my lord. I had instituted a suit. I sought for
That
that.
came to be transferred.
Yes.
Work with it. Issue interim order. First, this interim relief has been granted in the light of the coordinate bench decision. In ಏನಿದು ILR ಇದೆಯಲ್ಲ reported
Yes, my lord. Yes, my lord. It is.
which is that ILR decision in WP number 51187 of 2019 KLGP between Srimati Sunita versus state and others. ILR ಕೊಡ್ಬೇಕು.
Yes, my lord. I will provide.
ILR. Yeah, ಹೌದು. You can see it. Yes. ILR ಕೊಡಿ.
Yes, my lord. I will just.
ILR ಕೊಟ್ರೆ ಟೈಪ್ ಮಾಡೋದು.
Yes, I will provide.
ಆರ್ಡರ್ ಮಾಡೋದು. ಹಾ. Next.
Yes.
Yes, brother Tahir.
ಕೊಡ್ತೀನಿ.
ಏನಿದೆ?
This honorable court, before this honorable court for the correction or jurisdiction of criminal case law, criminal court's lordship. The case of the petitioner.
Ah.
That is. CC number, special CC 2263 by 2023 is pending in Bangalore lordship. The crime is committed in Hubli. Investigated by state police lordship.
Investigated by
By
state police.
Thus, as offense, schedule offense was involved, that is UAPA, for that reason, case was transferred from Hubli to Bangalore. So my contention before this honorable court is the case where it has been pending, now presently in Bangalore, it is a constituted under section 11 by the central government. Where the matter, central government,
Repeat.
NIA Act.
Repeat the
Where
statement.
the case is pending presently in Bangalore, there is a special court constituted under section 11 of NIA Act, which is a power bestowed to the central government to constitute a special court for the cases which is investigated by the NIA.
Yes, it's there.
Yeah, it is there. Then section 22 lordship, there is specific provision under section 22 where the power bestowed to the state government to constitute a special court where the investigation done by the state agencies.
There is a separate provision.
Yeah, separate provision. Lordship, kindly
The
take.
preliminary objection is, my lordship, we not made a party to central government. It's the competent authority to answer.
I will satisfy this court on all these aspects, lordship.
Yes.
Now, act is, I'll just forward the act, lordship.
You want this transfer of this
To Bang,
case
to Hubli, so the
from
session.
Bangalore to Hubli.
Hubli, lordship.
This at Bangalore, who had instituted this?
The central government has instituted.
Then central government is a necessary party.
No, lordship, the central government is not necessary party because the separate power has been specified.
That's all right. Now, proceedings are instituted by the central government.
No, lordship,
Not-
no, central proceeding is instituted by the state government.
State government.
Investigation done by the state government.
Act is from central government.
Huh?
Act is in central government. NIA Act.
Lordship, I'm
This
just,
Act even IPC is central government. Parliament.
section 22, lordship, kindly look, take
Sorry,
section 22. In
This is a
the petition
transfer
itself.
petition.
Yes, lordship.
Transfer from this court to Hubli court.
Hubli court. Page number 15 also I extracted in my,
Which section provides for that?
section 22, lordship,
22.
2. Section 22 of NIA
Of
Act.
state government to designate court of sessions as special.
I have
purpose.
extracted in my, in page number 15 also, lordship, 11 provision. In my compilation.
So the state government constitutes the court,
Court, its state government has not constituted.
designates a judge
Yes.
to be special court under 20.
Yes, 22. Lordship, kindly appreciate. There is a power of state government to constitute special court. The state government may constitute one or more special court for the trial of offence under any of all the enactments specified in the schedule.
Hmm.
The provision of this chapter shall apply to the special government, special courts constituted by the state government under subsection 1 and shall have the effect subject to the following modification, namely. Since now, lordship, subclause 3 is important, lordship. I am relying on that. The jurisdiction conferred by this act on a special court shall, until a special court is constituted by the state government under subsection 1 in the case of any offence punishable under this act, notwithstanding anything contained in this court, be exercised by the court of session of the division in which such offence has been committed, and it shall have all the powers and follow the procedure provided under this. So, lordship, the subsection 3 clarifies the position in the
Subsection-
event.
Go slow. Subsection 3 of
3 of section 22. There is a provision of deemed court.
The jurisdiction conferred by this act on a special court shall, until a special court is designated by the state government under subsection 1 in the case of any offense punishable under this act, not in the entire court, be exercised by the court of session of the division in which such offense has been committed.
Yes,
It is
Lordship.
committed in Hubli.
Hubli.
Therefore, that court itself will have jurisdiction anta ನೀವು ಹೇಳೋದು.
Yeah, session of that court will be,
All the powers and follow the procedure provided under this act.
yes,
The regular court will do it, but procedure will be followed under this act.
yes, Lordship. Special court will be, the deemed special court will be the principal district session judge of that particular division. That I could comprehend from this particular provision, Lordship.
ಧಾರವಾಡ
Lordship.
PDJ ಬರ್ತದೆ. ಧಾರವಾಡ PDJ.
Yes, Lordship, Dharwad please. Lordship, kindly, I have just.
One second, we have to think, it's not that simple, easy. On and from the date when the special court is designated by the state government, the trial of any offense investigated by the state government under the provisions of this act, which would have been required to be held before the special court, shall stand transferred to that court on the date on which it is constituted. In other words, the proceedings shall not be halted. The proceedings shall be held at Dharwad court. Whenever designated court is, whenever a special court is designated by the state government, the proceeding will stand transferred to that special.
That particular court. So
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ?
admittedly, Lordship, there is a no special court is constituted, designated by the state government of Karnataka. Lordship, in that aspect, Lordship, I have also filed a RTI, Lordship, before the register of this honorable court,
I
Lordship.
want to file my objection, my lord,
You want to file objection?
Lordship, I am,
File ಮಾಡ್ತೇನೆ.
within a week, my lord. Notice is not. at-
ಅಲ್ಲಿ ಯಾವತ್ತು post ಆಗಿದೆ matter?
that matter is every 14 days getting posted. I think this 17th, Lordship, matter is there.
17th of November,
16th of November, Lordship, the matter.
16th of November.
Yes, Lordship.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಬೇಡಿ ಹೇಳಿ.
Not-
You have raised one particular point which you have to answer.
Because Lordship, there is several aspects which I need to make mention.
Also, register civil court is also necessary party. my lord.
ಯಾಕೆ? Courts are not necessary parties ಈಗ. Latest judgment ಪ್ರಕಾರ. Judicial, quasi judicial shall not be arrayed as parties ಅಂತಾನೆ hold ಮಾಡಿ, except where a malafide is alleged against the judges of special courts. That is not his case, sir.
Lordship, one more must we should say.
Why can't you resist your temptation to argue?
Because
We are in your favor, you want to dilute that, argue that.
Lordship, there is one judgment pass in this court. I want to draw attention of that particular case.
Keep quiet. We are now, you have made some case now. What he says is, unless there is a court designated by the state government, there may be court designated by the central government is another thing. He says the offense is committed at Hubli and there is no, and it is being investigated by the state police agency and there is no special court designated by the state government.
Yes.
That's what information he has
My
received
lordship,
on
based
an RTI.
His case is only, my lordship, based on RTI given by the state government. in-
ಅಲ್ಲ ನಿಮ್ಗೆ ಕೊಡ್ತೇನೋ ಟೈಮು, ವಿಲ್ ಗಿವ್ ಯು ಟೈಮ್ ಬಟ್ ಡೆಸಿಗ್ನೇಟೆಡ್. ಪೇಜ್ 81 ಗೆ ಬನ್ನಿ ತಾಹಿರ್.
Or 81, Lordship. This is a point, Lordship, I want to draw the attention of this honorable court. Lordship, kindly, please, the same order also have annexed it, the same order, the government order, Lordship.
At page
Page is page number 53, Lordship. Page number 53.
16 ಗಿದೆ ಮ್ಯಾಟರ್ 16.
Yes, yes, 16.
Call this matter on 11th. Learned AGA is requested to accept notice for respondent.
13th, my lord.
Huh?
13th,
13th. On 13th. ಅವತ್ತು ಹೇಳ್ಬೇಕು.
please.
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Deeply obliged.
ಹೇಳಿಲ್ಲ. jurisdiction specify ಮಾಡಿದಾಗ both the courts will have jurisdiction ಅಂತ Justice Varaiva of Bombay has said in Pada. Essay Varaiva then he went to Supreme Court. He has said where two courts are designated and we do not know which of the two will exercise. Matter will come soon. Designated courts. In every case. Case specific designation, huh? ಅಲ್ಲಿಗೆ ಬರುತ್ತೆ. As amongst themselves. Only so, then no case. Otherwise, you have to follow the petition. Yes. Ah. Settlement ಇದೆ.
That's serial number 22, my lords.
Yes, brother.
My lords, I appear on behalf of the appellant, my lords.
Ah.
The parties are settling the matter, my lords.
Yeah,
The
we
settlement
settled.
terms are yet to be finalized, my lords. May I pray that the matter may be adjourned for a period of 3 weeks, my lords. We'll report the settlement.
Counsel for the appellant submits that the talks for amicable settlement are in progress and hopefully amicable settlement would be arrived at and therefore seeks 3 weeks time. First stop. Agreed. Full stop. Call after 3 weeks
Grateful, my lords.
for reporting settlement. Brother. 21 adjourn ಆಗಿದೆ ಅಲ್ಲ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟಿದ್ದೇವಲ್ಲ, ಯಾರು ನಿಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ನ ತಗೊಂಡಾರನು ಅವರು? ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟೇವೆ, ಡೇಟ್ ಕೊಟ್ಟೆ. ನಮ್ಗೇನು ಹೇಳಿದ್ರು, ನಿಮ್ಗೆ ಹೇಳಿದೇವಿ ಅಂತ ಹೇಳಿ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರ ಅವರು. ಎಸ್. Yes, brother. ಯಾರು? ರಾಜಶೇಖರ್. None appears. Call in the 3rd week of January 25. Nobody, are they unhappy with us or what? ಒಬ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳ್ಬೋದು, ಇಬ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ they are unhappy with the judges ಅಂತಾನೆ. All pass over. Yes, Ashok Kumar ಏನಿದೆ?
For the petitioner in this matter.
Where for the first petitioner's counsel?
Petitioner's counsel.
Lord, the short question is, when the first auction fails and it does not perform, they take the property by paying money, can it be given to the second bidder?
What's the law on the point? What is the law on the point?
The law on the point, the rules do not provide for it.
Where is there is some decision of
Section-
Apex Court.
Orissa High Court says you cannot do a second auction. You have to do a second auction. You cannot give it to second bidder. Because suppose second bidder fails,
How this question is answered by the Supreme Court, Honorable Supreme Court? What?
Supreme Court, Lord, One case. In the Supreme Court, is
At present.
Matthew case. But they don't.
This aspect is considered by the apex court, na?
ಇಲ್ಲ.
In, no, it's considered.
Second bidding ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
Law of auctions by Devatia. He has discussed this aspect of the matter.
My friend cautioned me.
Ah.
You will face these kind of questions from the judge.
ಹೌದು. ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀವಿ. ಹಾಗಾಗಿ ಯಾರು ಏನ್ ಹೇಳೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ.
ಮಾಡ್ತೀವಿ, ಅದು ನೋಡ್ಕೊಂಡು ಬರ್ತೀವಿ.
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
ಶಾರ್ಟ್ ಡೇಟ್, ಯಾಕಂದ್ರೆ
ಹೇಳಿ
ಈಸ್ ಆಲ್ರೆಡಿ 75 years.
ಹಾಲು ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
He is only a guarantor.
ಇದು ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್ ಅಲ್ಲ ಇದು.
ಇಲ್ಲ, ಅಪೀಲ್ ಎಲ್ಲ ಆಗಿತ್ತು. ಇದು ಫ್ರಮ್ DR80
ಆಗಿದೆ.
DR80 ಇಂದ ಬಂದಿದೆ.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ?
Petitioners have succeeded before the DRT.
DRT reversed
set
it.
aside the sale. DRT reversed the order.
ಅದು ಏನ್ ರೀಸನಿಂಗ್ ಏನಿದೆ?
They say that sale certificate is not a measure,
Sale certificate is
not a measure. And
not a measure and therefore
we cannot entertain the. Therefore, the DRT order was.
Because sale certificate is issued after the auction is over. That is the document on which I go and purchase the property.
Lord may kindly see rule 9(3) in this aspect.
ಅಲ್ಲ ಅದ್ರ ಮೇಲೆ ಒಂದು ಓದ್ಕೊಂಬನ್ನಿ. ಡಿಬೇಟಿಯಾ ಓದ್ಕೊಂಬನ್ನಿ. ಅದು ಓದ್ಕೊಂಬಂದ್ರೆ ಕರೆಕ್ಟ್ ಆಗ್ತದೆ. ಇಲ್ಲಪ್ಪ ನಾವೇ ಓದ್ಬೇಕಾಗ್ತದೆ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂತ ತಾವು ಹೇಳಿದೀರಾ, ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀವಿ.
ನೋಡ್ಕೊಂಬನ್ನಿ. Devatia on law of auction.
Lord, kindly give a short date.
All right, ಹೇಳಿ ಯಾವ ಡೇಟ್ ಬೇಕು? Whichever date you want.
Next week.
Right. Call this matter on
12th.
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 IAS matter 13th ಆಗ್ತದಾ?
15th, my lord.
15th ಆಗ್ಬೋದಾ?
15th.
Your Lordship, please.
Okay. Even if it is held to be not a measure, your right to challenge in WP will remain intact only, even otherwise.
Because the question of law is whether rules permit a second auction, permit a
The
second
next
bidder to
bidder.
be given the sale. Because it has to be re-auction. You can, second bidder fails, third bidder ಹೋಗ್ಬೋದಾ?
It cannot go to
Cannot
the
go like that.
next below anta.
And I have paid him, I have said, I am prepared to pay the entire amount. I deposited 15 crores. Please relieve me of this obligation.
What is the second bid amount? Second
Our
bidder's
11
amount.
11 crores.
3 crores.
11.3 crores.
First bidder offered 12.88.
And you want to give how much?
ನನಗೆ ಒನ್ ಟೈಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಒಪ್ಕೊಂಡ್ರು 21 lakhs crores ಕೊಟ್ಬಿಡ್ತೀವಿ ಅಂತ. I deposited 15 crores immediately.
Only 6 crores.
Balance I am willing to pay. I am only a guarantor. I am not the person who has taken the loan.
All right, ಅವ್ನು ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. 15 ಒಂದ್ಸರಿ ನೋಡ್ಕೊಂಬನ್ನಿ.
My lord, please.
ಯಾವ ಕೋರ್ಟು ಡಿಸೈಡ್ ಮಾಡಿಲ್ವಾ ಈ ಪಾಯಿಂಟ್ ಮೇಲೆ?
ಇಲ್ಲ.
No, my lord.
ತಾವೇ ಹೇಳ್ಬೇಕು.
Orissa division bench says.
Second bidder cannot be given. You have re-auction ಅಂತ ಹೇಳ್ತಾರೆ division bench. Please terms. And your lordship will have to.
Once the auction is failed, the secured creditor has no other option but to re-auction the property.
Unless law provides
ಅಂದು
otherwise.
he forfeits rule 9. He forfeits the amount also. ಅದೆಲ್ಲ ಏನು ಫಾಲೋ ಮಾಡಲ್ಲ. ಇದೇನು ಆಕ್ಷನ್ ನನಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಅದು ಯಾರು who is paid all this. And your lordship kindly sees first up bidder comes to this court and gets back his money. Contrary to rule 9.
Fresh
ಹೌದು.
appears to be the
And
requirement.
this court allows him to give an application to ARCL. ಅವರು ಹೋಗಿ ಲೆಟರ್ ಕೊಟ್ಟ ತಕ್ಷಣ ಅವನ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡ್ಬೋದು. ನಾನು ಸಿಕ್ಕಾಕೊಂಡು.
ಕನ್ಫರ್ಮೇಶನ್ ಆಗಿದೆ ಏನದು ಇದು ಆಕ್ಷನ್?
Sale certificate.
Sale certificate issue ಆಗಿದೆ.
DRT set aside the sale, my lord.
Okay.
ಅದು what was reversed by the DR.
DRT says there is no.
Not a measure ಅಂತ.
No, DRT says.
That's what. DRT says it is not a measure,
Not a
therefore DRT could not have set it aside.
ಹೌದು.
Because DRT observation is, it is an offshoot of sale notice, it's not a sale notice. In fact, my lord, when I challenged the sale notice, there was an interim order which was in force. During the pendency of that essay only, they have confirmed to the second auction purchase.
No, the learned senior advocate has raised that particular issue, na? The other side has to comment,
And sufficient
Yes, sir.
time has been given for filing their objection and.
ಏನ್ ಮಾಡಿಲ್ಲ ಅವರು
4 months, my lord.
4 months time
they
ಕೊಟ್ಟಿದ್ದಾರೆ.
are afraid of your argument now.
ಇಲ್ಲ ಇಲ್ಲ, they are afraid of your lordship's words. ನನ್ನ ನೋಡಿ.
In
Call
fact-
this matter
in
on
fact,
15th,
after this-
15th ಗೆ ಹಾಕೋಣ, ನೋಡ್ಕೊಂಬನ್ನಿ.
In fact,
On
after this
15th.
order, they have given a OTS, I have paid 15 crores, only 6 crores is pending because. of
Now we are willing to pay that also. ಅವ್ನು ಹೇಗೆ ಸಾಯ್ತಾನೆ ಸಾಯಿ ಬಿಡಿ ಅಂತಾರೆ. ನಾನು ಏನ್ ಮಾಡ್ಲಿ?
Call this matter on 15th
Much
to
obliged.
enable counsel appearing for the respondent to come and argue. Response 1 and 2 to come and argue. Respondents 1, 2 and 3 to come and argue.
Let interim order be extended.
Entry order ಇದೆಯಾ? Entry order to continue. ಮತ್ತೆ entry order ಇದ್ರೆ ಬರ್ಲಿ ಜನವರಿ.
ನಾನು ಟ್ರೈಲ್ ಹೋಗ್ತಾನೆ.
Okay. All.
Sorry, bro.
All right. Yes. ಪ್ರಮೋದ್ ಏನದು?
There are two matters, my lords. One is filed by the department, other is filed by the.
ನಿಮ್ ಫ್ರೆಂಡ್ ಇಲ್ಲಲ್ಲ, ಸಾಮಾನ್ಯವಾಗಿ ಇರ್ತಾರ ಅವರು. ಬಂದಿದ್ದಾರಲ್ಲ ರಂಗನಾಥ್ ಜೈಸ್ರು. ರಂಗನಾಥ್ ಜೈಸ್ರು ಆಕಾಶದಲ್ಲೇ ನೋಡ್ಬೇಕು.
ಇಲ್ಲ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಲ್ಲಿಗೆ. ವಿತ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಅಬ್ಸರ್ವೇಷನ್ yesterday I want to physically come, my lord. Just give a day, short date, next week I will come and physically argue.
ನೋಡ ಏನೋ ರೂಲಿಂಗ್ಸ್ ಏನ್ ಸೈಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ತಾನೆ?
Yeah, ruling fight ಮಾಡ್ತಿಲ್ಲ, but ಸ್ವಲ್ಪ ಇದು enquiry matter I have to physically present. I have to come. Short date, next week I'll ಮಾಡ್ತೀನಿ.
ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. ನೋಡಿ ಯಾವ್ದು ಸ್ಲಾಟ್ ಯಾವ್ದು? 27th ಬನ್ನಿ.
ಬರ್ತೀನಿ.
At the request of Mr. Rangnath Jais. Okay. Yes, Vijay Kumar ಏನಿದು?
In this case, the petitioner had approached the tribunal seeking to count the past service rendered by him as a clinical registrar for the purpose of career advancement progression, that is the dynamic assured progression scheme. That scheme was available for clinical staff also. But he was initially appointed as a clinical registrar in 2004. In 2012, my lord, he was appointed as a lecturer. But he is a doctor by profession. And my lord, the DACP scheme extends to the teaching as well as non-teaching posts. But after his appointment as a lecturer, my lord, he only sought to count the past service rendered for extending the benefit of DACP scheme to the applicant. But that has been rejected on the ground that you are not working as a doctor at the relevant point of time and clinical staff is not entitled for DACP scheme. Now, the government order specifically says that it is available.
ಯಾವ್ದು?
Page Annexure A17.
ಪೇಜ್ ಹೇಳಿ.
118.
But before that, my lord, Annexure A5 may kindly be seen.
5. '81.
Page 81. my lord. This is available for medical officers. And my lord,
ಏನಿದು?
the scheme of DACP, that is Dynamic
Dynamic
Assured Career
Assured
Progression
Career
Scheme is
Progression.
available.
ACP scheme ಇದು.
Yes, ma'am.
Senior, up to senior administrative grade, SAG level, up to,
Yes,
in respect of officers of Central Health Service and dental doctors under the Ministry of so and so, so and so. So ಯಾವ್ದ್ರಲ್ಲಿ cover ಆಗ್ತಿದೆ?
but this benefit was extended to the non-teaching clinical research staff also, my lord. Your lordship may kindly come to page 120, my lord. Annexure A18. Medical clinical specialist supportive clinic research staff. But they have also been extended the benefit of DACP, my lord.
ಏನಿದು?
This is the extension of dynamic assured career progression scheme in respect of Ayush doctors. non-teaching staff.
To extend the benefits of DACP scheme to non-teaching staff.
Teaching
staff
staff.
of Ayush. No.
Yes, ma'am. I was
Ayurveda,
Unani.
Unani,
yeah,
Siddhi.
AYU. Unani.
Siddhi.
Ayurveda,
Siddhi
Unani,
and
Yoga,
homeopathy. Siddhi and homeopathy.
Siddha and homeopathy. ನೀವು ಯಾವುದು?
Not
Unani.
Unani.
ಯುನಾನಿ. ಏನ್ ಹೇಳ್ತೀರಿ ಇದ್ರ
My
ಬಗ್ಗೆ?
lord, earlier he was appointed as a clinical registrar on 22nd October 2004. He was in non-teaching staff cadre.
ನಾನ್ ಟೀಚಿಂಗ್ ನವ್ರಿಗೆ ಇಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ?
I will just try to. Then, my lord, he applied for the post of lecturer.
Yes.
Then he was appointed as a lecturer on 24th March 2012. So earlier he was in non-teaching cadre. Later he applied for the lecturer post.
Came teaching.
He came to the teaching. So for him, my lord, that is the A17, page number 118. That particular scheme is applicable, and he will be promoted after putting certain year from lecture post to the assistant professor. But his past service as a clinical registrar cannot be taken into consideration
Really,
because it is
hanging
a separate cadre itself.
Maybe, where is that?
Yes, my lord.
That, see,
Yes, my lord.
you have come to A5, page 81.
Yes, my lord. Yes, my lord.
It says,
Yes, my lord.
extension of dynamic assured career progression scheme up to senior administrative grade.
Yes,
Up
my lord.
to,
Yes, my lord.
from Pune up to,
Yes, my lord.
all they will fit into that embrace.
Yes, my lord. In the year 2008, my lord, this particular scheme was introduced with respect of Ministry of Health and Family Welfare.
Correct.
Thereafter, my lord, in the year 2015, this particular scheme with reference to Annexure A17 separately for the teaching staff and with reference to teaching staff, my lord, separately it has been introduced. So after taking the approval of the Department of Expenditure, my lord, and accordingly, this has been introduced by this particular Ministry of Ayush, my lord.
Extend the said, family come to page A17.
Yes, my lord.
118.
Yes, my lord. Yes, my lord. I will read it, my lord. In suppression of this ministry OM of
Supersession.
is in superstition of ministry's OM dated so and so, the undersigned is directed to say that conditional concurrence given by the Department of Expenditure regarding grant of DACP benefit has been reviewed by expert committee constituted in this regard. In consultation with the Integrated Finance Division, it has now been decided to extend the said
DACP scheme
up to SAG level.
SAG level. Andre. In the pay band of so and so, up to ಅನ್ನೋ word ಇದ್ದಾಗ.
Yes, my lord. To the teaching staff of the Ayurveda.
Huh?
To the teaching staff of Ayurveda. If he continued in the teaching, if he continued in the non-teaching staff, my lord, then my lord, that particular OM is applicable and he can be extended. Since he has not continued in the non-teaching cadre, my lord, now he has shifted from one cadre to another cadre.
How that will wipe out his service, whichever service he has rendered.
My lord, this is a separate cadre itself, my lord. And his past services cannot be taken into consideration. If in the same cadre, if he had applied and if he has.
How you operated this scheme earlier in respect of other employees? Other employees game ಮಾಡಿದ್ದಾರೆ ವಿಜಯ್.
Not other employees have been extended that benefit, my lord.
ಎಲ್ಲಿದೆ?
That I have produced as annexure.
A5.
Not page 146, my lord.
146.
Yes, ma'am.
ಎಲ್ಲರೂ ಡಾಕ್ಟರ್ ಇದ್ದಾರೆ ಇದರಲ್ಲಿ.
Last paragraph, page 147.
147, all are doctors.
No, clinical registrars.
Huh?
Present post held is clinical registrar.
Clinical registrars, yes. Non-teaching. ಇದೆಯಲ್ಲ?
Well, the clinical registrar in the same cadre, my lord, that promotion has that upgradation has been given. If my lords look into serial number 23.
Whether clinical registrar is a teaching post?
No.
Yes, ma'am. Yes, ma'am.
It is a non-teaching.
Page 79. ma'am. Page 79. It shows that it is a teaching and a research.
79.
Yes, ma'am. It is a certificate issued by the second respondent. Last, the nature of work of Dr. Muhammad Shakil Ansari, clinical registrar, is surgical OPD, IPD duties, including what teaching of PG.
PG students. ಇನ್ಯಾರು issue ಮಾಡಿದ್ರು?
The second respondent.
The director, deputy director.
Yes.
ನಿಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
Yes. Second respondent.
ಸೆಕ್ಷನ್ ತೊಳಿ. ಬಟ್ ಈ ಬೆನಿಫಿಟ್ ಇವ್ರಿಗೆ ಕೊಡಿ, ಅವರಿಂದ ರಿಕವರ್ ಮಾಡಿ.
My lord, my instruction is that, my lord, he is in a non-teaching staff, my lord.
Huh.
He is in that particular
ನಿಮ್ಮ
cadre.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತೊಗೊಂಡು ನಾವ್ ಏನ್ ಮಾಡೋಣ ಬ್ರದರ್? ನಿಮ್ಮ ರಿಟರ್ನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನಿದೆ ರೆಕಾರ್ಡ್ ಆಫ್ ದಿ ಪೇಪರ್ಸ್ ಅದು ನಮ್ಗೆ ಇಂಪಾರ್ಟೆಂಟ್.
My lord,
ವಾಟ್ ಅದರ್ ವಿಲ್
the
whisper into your ear?
nature of work, what he has done, my lord, it has been explained. It has not been declared that or certified that he is in the he is in the teaching staff, my lord. He is in the teaching staff cadre. Yes, ma'am.
Not teaching staff.
Yes, ma'am.
Had continued in the non-teaching staff.
Yes, ma'am.
Then,
cadre itself, only then he would have got. And if he was in teaching,
Yes,
and if only he continued in teaching, he
teaching.
would have got.
Yes, ma'am.
Because there is a jump from this to this, he is
Yes,
not.
Yes, ma'am. That is,
The logic of that.
Logic discriminatory act. These are all intended to benefit a class of people, and they are in recognition of the past service.
Yes,
And under contract law, which K.C. Shawaksha on Mullah's contract law, he writes, past consideration is also a consideration in all civilized jurisdictions of the world. He has served. It is not that he is claiming something for something which he never did. Your case is not that he has not served.
no, it is not our case, my lord.
That cannot be counted here is your contention.
My lord, only my submission is that, my lord. Only my submission is that, along with others, he was appointed on 26th March 2012.
Correct.
And if he is given, if his past service is taken into consideration,
So others also have to be, you have to be.
my lord, in that,
The intent.
that is, that,
Many people will come to my clinic. If I open the doors of my clinic, yes, many people will come. You have to treat everybody. Your duty bound to treat that way.
my lord, the financial upgradation, he is entitled only when he has taken birth in that particular cadre, and that particular services can be taken into consideration. His past service in another cadre cannot be taken into consideration, my lord.
By and large,
Yes, ma'am.
almost similar matter. Dr. S.S. Nodam, Dr. S.S. Vishweshraya versus Karnataka University. ಆ ಜಡ್ಮೆಂಟ್ ತೊಗೊಂಬನ್ನಿ ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಅಲ್ಲಿ ಪಾಸ್ಟ್ ಸರ್ವಿಸ್ ಇನ್ LIC. Professor S.S. Vishweshraya, of great teacher of administrative law in Karnataka University Law College. His
Yes.
case is ali into by and large little that way. Justice
sir.
Anand Bhaira Reddy's judgment.
And the qualification prescribed for both clinical registrar as well as lecturer is
Same.
one and the same.
Same. ಇದೊಂದು ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಬನ್ನಿ
Please.
ಜಡ್ಮೆಂಟ್ ತೊಗೊಂಬನ್ನಿ ಅನ್ರಿಪೋರ್ಟೆಡ್. ಅಲ್ಲಿ two aspects it. ಒಂದು, service rendered in LIC cannot be counted because it is not a teaching service. The other was gap between he is leaving LIC and joining the university was longer than what was prescribed. These two issues I remember.
But in this case, Maladi is not,
Not the-
not
that's
there, no
not the
gap.
point.
Immediately he has
This is
reported.
that,
Yes.
Geraldine.
I will
What
just
come
look into that,
ಯಾವತ್ತು?
a week's time.
Call this matter. So and so. Part service ಮಾಡಿರ್ತಾರೆ, ಕೌಂಟ್ ಮಾಡ್ಬೇಕು. Part service should not go uncounted ಅನ್ನೋ ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲೆ ಮಾಡಿರ್ತಾರೆ ಅದನ್ನ. Yes.
Clarification is required regarding the
ಯಾವ್ದು?
pay scale in the refixation is.
ನಮ್ಮ ದೇಶಪಾಂಡೆ ಅವ್ರ ಮ್ಯಾಟ್ರ್.
ಅಲ್ಲ,
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್. ಯು ವಾಂಟ್ ಟೈಮ್?
instructions give 1 week time.
ಆಲ್ ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದೇ ಹೌದು 32. ಆಲ್ ರೈಟ್. It's the request of government.
There is an interim order in my favor.
Interim order to continue, call after 3 weeks.
Great.
Yes.
It is. Is.
Whereas for the first petition and last provisional pension, DCRG and commutation agreement. For the second petition, only provisional pension.
No, at least something is given to you to hold body and soul together. That was the object of that order. Not. Complement ಆಗಿದೆಯಾ?
Yes, my lord. Provisional pension is given to both. The
Learned
variant.
AGA appearing for the official respondents submits that in terms of order dated 14/8/2024, correct?
Please, my lord.
14/8. 14/8 ಇರ್ಲಿಕ್ಕಿಲ್ಲ. You were not here, no? It was my order
Tin-
or the order of the coordinate bench.
Yes, my lord.
In terms of coordinate bench order dated 14/8/2024, some pensionary benefits are extended, granted to the petitioners. First, counsel for the petitioner finds fault with the same, contending that what has been awarded to the second petitioner is not fully awarded to the first petitioner. Athwa reverse, awarded to first petitioner has not been awarded to the second. First, we'll examine it. Next week, difficult, Vijay, because we are held up in too many matters. We'll have it in the.
But as per the rules, there is a provision for promotion to the post of library. But having the qualification.
23 sitting, 23rd is sitting. 23rd is not.
Please, my lord. This is only through direct recruitment, my lord. Librarians can be promoted.
Where are the date? 25th.
Obliged.
All right.
Obliged.
And
Yes.
for the petitioner, my lords. My lord, matters at 34 and 35 are both from the same parties. Petitioner is the same in both. In the first petition, it is about his compulsory retirement made in public interest. Whereas second petition is about initiation of inquiry on the same charge of a criminal case after giving
Sit
punishment.
down. ಅಲ್ಲೇ ಕೂತ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಫಸ್ಟ್ ಲೈನ್ ಕೂತ್ಕೊಳ್ಳಿ ಕೇಳಿ. ಕೂತ್ಕೊಳ್ಳಿ.
And on the last occasion.
Ready? Are you ready?
My learned friend informed me, my lord, he would be taking time.
Asking. Are you ready?
Lord,
Allah, if you want time, we'll give you. We'll answer the question of the answer.
Lord, I was ready, my lord. I'll go through once again and make my submissions, my lord, because it was informed me that he would be taking time, my lord.
ಯಾವತ್ತು argue ಮಾಡ್ತೀವಿ?
Lord, any convenient date. There is an interim order undertaken fairly by my learned friend that he will not continue with the inquiry in the second case. If that is extended, my lord, any convenient date may be taken up, my lords.
Call this matter in the third week of January 2025. First up, interim order granted by the coordinate bench. Interim arrangement made by the coordinate bench shall continue.
My lord, can it?
Till then.
My lord, that was interim arrangement as undertaken by the.
ಇದರಲ್ಲಿ ಏನಿದೆ ಅದೇ that will continue. Yes.
Both the matters.
ಅದು ಕಾಲ್ along with ಮಾಡ್ಬೋದೇನೋ? Call along with each other.
Lord, the same order be also reflected in second petition, that is inquiry matter.
ಅದಿದೆಯಾ?
At the order same ಬಂದಿದೆ.
ಎರಡಕ್ಕೂ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡೋಣ. Okay.
Previously also both same. Great.
Petitioner. Matter maybe have it next week. ಅದರ ಒಂದು judgment ಅದು collect ಮಾಡೋದು.
This is also my lordship, final order, conviction as well as recovery of the land.
Conviction and recovery. So appeal lies. Appeal ಮಾಡ್ಬೋದು.
That aspects already decided by the earlier occasion, my lord. The coordinate bench of this honorable court, my lord.
ಏನಂತ?
ಅದ್ರ ಬಗ್ಗೆ ಡಿಸ್ಕಸ್ ಮಾಡಿ ಅದ್ರ ಬಗ್ಗೆ ಸೀನಿಯರ್ ಅಪಿಯರ್ ಆಗಿದ್ರು ಸೊ ಆ ಟೈಮ್ ನಲ್ಲಿ ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲಾಂಗ್ ವಿತ್ ಸಮ್ ಜಜ್ಮೆಂಟ್ಸ್ my lord will convince your lordship, my lord.
ಏನ್ judgment we have held that
No,
appeal?
my lord, that aspect also decided by the earlier coordinate bench, my lord.
ಯಾವ್ದು?
Interim order grant ಮಾಡುವಾಗ ಅದನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡಿನೇ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿರುತ್ತೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಕೊಡಿ. ಆ ಆಸ್ಪೆಕ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಯಾರ?
ಅದ್ರ ಬಗ್ಗೆನೇ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ರು ಸರ್.
ಇದು ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. This order is dated 25 July 2024.
Yes,
It's appealable. 2020, law is amended. 21. Law is amended. Now we'll protect you also.
please.
Till you file appeal,
Much
we'll
obliged.
protect you
Yes, ma'am.
also.
Yes.
Keeping, issue keep open ಮಾಡಿದ್ರು. Keep open ಮಾಡ ಆಗತ್ತಿಲ್ಲ because we have decided in the morning matter, na?
Please, ma'am.
ಬರ್ಕೊಳಮ್ಮ. The challenge in this petition is to the special court's order dated 25/7/2024 entered in LGC bracket nalli T number 99 of 2020, whereby wherein the operative portion reads as under. Madam. Page 30 ಇಂದ ಮಾರ್ಕ್ ಮಾಡಿದೆ ನೋಡಿ. ಆರ್ಡರ್ ನೇಮ್ ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೋಟ್ ಮಾಡ್ಯಾರ ಅವರು ಹಿಂದಿನ ಬೆಂಚ್, ಅದನ್ನ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡ್ಕೋಬಹುದು. ನೋಡ್ಕೊಂಡು ಮಾಡಿ. ಪೇಜ್ 30 ಇಂದ 31 ವರೆಗೆ ಕೋಟ್ ಆಗಿದೆ ಹಿಂದಿನ ಆರ್ಡರ್ನಲ್ಲಿ, ಅದು ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡ್ಕೊಬಹುದು. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. Learned AGA appearing for the respondents draws our attention to the provisions of section 17 capital A1 A1 to the so and so act ಇದೆ ನೋಡಿಕೊಳ್ಳಿ. And submits that which provides for a right of appeal against orders of the kind. First off, he also submits that in WP number so and so, between so and so disposed of by this court this day, the litigant has been relegated to appellate remedy. And therefore, the same should happen to the petitioner herein also. First off, there is force in this submission.
12006
ಅದೊಂದು ನಂಬರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನದು
11.
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ನಲ್ಲಿ ಬರ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. In the above circumstances, this petition is disposed of, reserving liberty to the petitioner to avail the remedy of appeal. First off, the period appeal, keeping open all contentions of the parties. First off, next paragraph. The period spent in prosecuting this petition shall be discounted while computing the period of limitation prescribed for the said appeal. First off, registry to return the impugned order to the petitioner after retaining a copy thereof in the file. First off. Next, to facilitate filing of the appeal, the impugned order shall not be is kept under suspended animation the interim order granted by the coordinate bench on 13/9/2024 shall continue for a period of 4 weeks. 4 weeks. 4 weeks. ಇದಕ್ಕೊಂದು ಆಂಧ್ರ ಪ್ರದೇಶ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ, ಅದು ಕೊಡ್ಬೇಕು, ಯಾರು ಮಾಡ್ಕೊಂಡಿದ್ದು ಅದರ ಡೇ. Interim order can be continued even after disposal of the main petition ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ತಾರೆ ಆಂಧ್ರ ಪ್ರದೇಶ್ ಡಿವಿಷನ್ ಬೆಂಚ್. BL Hansaria on writ jurisdiction. ಅದನ್ನ ಹುಡ್ಕೊಂಡ್ ತಂದು ಕೊಡ್ಬೇಕು, ಲೈಬ್ರರಿಗೆ ಹೋಗಿ ಅದನ್ನ ನೋಡ್ಕೊಂಡು ತಂದು ಕೊಡ್ಬೇಕು. Writ court can extend interim order even after final disposal of the writ petition to facilitate appeal and hold ಮಾಡಿ beyond the period of this one ಅಂತ ಬರ್ಕೋಬಹುದು. ಆಂಧ್ರ ಪ್ರದೇಶ್ ಹೈಕೋರ್ಟ್ ಅಂತ. ಓಕೆ, BL Hansaria ಅಂತ ಬರ್. Yes. No cause.
I pay for the petition.
ಏನಿದು ಪ್ರಮೋದ್?
Lords, here, my lords, in earlier round of litigation, my lords, the respondent applicant was granted temporary status, my lords, which we had given it, my lords, from the previous date, and even we had paid 20 lakhs and odd to the applicant, my lords. Later on, he is asking for a regularization from 10 years when he has completed the service, my lords. That is under challenge before this on court. That's
ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಫ್ರೆಂಡ್? ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನು?
ಇದೆ sir.
Call this matter in the first week of February. First off, interim order to continue.
In
The first week of February to enable counsel for the respondent to come and argue. First off, interim order to continue.
ಇನ್ನೊಂದು ರಿಕ್ವೆಸ್ಟ್, ಅದ್ರ ಹೆಸರು ಪ್ರಮೋದ್ ಬಿ ಅಂತ ಬರುತ್ತೆ, ಅವ ಕಾಸ್ ಲಿಸ್ಟ್ ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತೆ. ಬಿ ಪ್ರಮೋದ್ ಅಂತ
Registry to show petitioner's counsel's name as Shri B Pramod.
Please.
Okay.
I pay for the respondent.
Yes, Mr. Gupta.
My lord, in this case, original DPC was held in March 2018. At the time of original DPC, complete dossier of APAR was not available. Therefore, his name was not considered. At the time of original DPC, the applicant was clear from vigilance angle. Thereafter, he was issued one charge sheet in October 2018. Review DPC was held in December 2018. At the time of review DPC, because charge sheet was pending, his case was put in sealed cover. Otherwise, he was fit for promotion. But as per DOPT instructions, review DPC can only consider the vigilance angle at the time of original DPC. Charge sheet issued after original DPC cannot be considered for promotion. There are DOPT instructions. In this case, in second round of litigation, the tribunal dismissed my case on the ground that 1 or 2 DOPT OMs are not sufficient.
To go for sealed cover procedure, we are saying it from reading 214. 214 2B2. KCR sir. ಅಲ್ಲಿ ಚಾರ್ಜ್ ಮೆಮೊ ಸರ್ವ್ ಆಗಿರ್ಬೇಕು.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, ಲಿಟಲ್ ಬಿಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಡಿಫರ್ಸ್. ಫಸ್ಟ್ ಟೈಮ್ DPC ಕಾಲ್ ಫಾರ್ ಆದಾಗ, ನಾಟ್ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಅಪ್ಲಿಕೆಂಟ್ ಮೆಲೋಡ್ಸ್, nearly 30 offices files were not available, dossiers were not available. So it was postponed, Melods, to the next date.
Correct.
In between the date of the first DPC, Melods, charge sheet was issued to him.
That is, it was postponed.
ಹೌದು, ಪೋಸ್ಟ್ಪೋನ್ ಆಯ್ತು. ಇವ್ರು ಒಬ್ರಿಗೆ ಅಂತ ಯಾರಿಗೂ ಇದ್ ಮಾಡಿಲ್ಲ, ಎಲ್ರಿಗೂ 30 ಜನಕ್ಕೆ ಆಯ್ತು. ಯಾರ್ಯಾರ್ದು ಬರ್ಲಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಲಿಲ್ಲ.
ಮೆಮೊ ಇಶ್ಯೂ ಆಗಿತ್ತಾ?
ಸೆಕೆಂಡ್ ಟೈಮ್ ಡೇಟ್ ಹಾಕ್ತಾರೆ,
ನೆಕ್ಸ್ಟ್ ಅಜರ್ನ್ ಡೇಟಿಗೆ ಇಶ್ಯೂ ಆಗಿತ್ತು.
Ajin ಆಯ್ತು. In between, charge memo is issued. That is noted by the review DPC. It has done and it is kept in the sealed cover. And here,
Principal na MS Tirthalingappa versus not the judgment. MS Tirthalingappa versus Karnataka Land Army Corporation. That is the sealed procedure, sealed cover procedure can be resorted to as on the date the DPC takes up the matter for consideration.
Yes.
Suppose today DPC takes up the matter and matter is again adjourned DPC. On the next date, first date there was nothing against you. As on the next date, something comes up, DPC can resort to this procedure. This is what Apex Court has said. Our court also has followed that. If that is done, how you are agreed? Where is the review DPC?
Review DPC was held in December
Where is that? Where is that? ಅದು review DPC na same DPC continued.
No, my
ಈ
lord.
ಪ್ರಕಾರ.
No, my lord.
ರಿವ್ಯೂ ಡಿ ಪಿ ಸಿ ಅಂತಾನೆ ಹೆಸರು ಹಾಕಿದ್ದಾರೆ. ಅಂದ್ರೆ ಯಾರ್ದು ಆಗಿರ್ಲಿಲ್ಲ ಅವಾಗ ಅದ್ ಮಾಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಯಾರ್ದು ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಲಿಲ್ಲ, 30 ಜನದ ಆಫೀಸರ್ಸ್ ಯಾರ್ದು ಇರ್ಲಿಲ್ಲ, ಅವ್ರದ್ದು ಪೋಸ್ಟ್ಪೋನ್ ಆದಾಗ ಅವಾಗ ಮಾಡಿದ್ದಾರೆ. ಅವಾಗ
ರಿವ್ಯೂ DPC ಆಗಲ್ಲ.
ಅದ್ರ ರಿವ್ಯೂದು ಬರಲ್ಲ.
That will not be review DPC, whatever they may call it.
ಆ ಹೆಡ್ಡಿಂಗ್ ನಲ್ಲಿ ಹಾಕ್ಬೇಕಾದ್ರೆ ರಿವ್ಯೂ ಡಿ ಪಿ ಸಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಬಟ್
ಹಂಗ್ ಬರಲ್ಲ.
ಅದನ್ನ ರಿವ್ಯೂ
DPC
ಮಾಡ್ಲಿಲ್ಲ.
ಆಗಲ್ಲ.
ಅದನ್ನ ರಿವ್ಯೂ ಮಾಡಿಲ್ಲ. ಅದಲ್ಲದೆ 2 ಚಾರ್ಜಸ್ ಇದೆ. ಒಂದ್ರಲ್ಲಿ ಪನಿಷ್ಮೆಂಟ್ ಆಲ್ರೆಡಿ ಇಂಪೋಸ್ ಆಗಿದೆ.
ಇಂಪೋಸ್ ಆಗಿಬಿಟ್ಟು.
ಒಂದ್ರಲ್ಲಿ ಇಂಪೋಸ್ ಆಯ್ತು. He has challenged it before this honorable court in a writ. It was challenged before CAT. CAT has passed CAT.
And here also failed.
And against that he is filed it. It's pending.
That WP is pending.
That is pending. In
We'll call that WP also along with this. ಯಾರ ಮುಂದೆ? ನಮ್ಮ ಮುಂದೆ ಅಲ್ಲ. ಬರಲ್ಲ.
My lord.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಎಲ್ಲ ಪ್ರೋಸೆಸ್ ಆಗಿದೆ, ಎನ್ಕ್ವೈರಿ ಆಗಿದೆ. UPSC consultation ke it has been forwarded. We are awaiting, my lords. After that action taken in that respect. And he has also retired, my lords, in the year 2019 itself.
ಅದು ಮುಂದೆ ಎಷ್ಟು ದಿವಸ ಇಡ್ತೀರಿ ಅದನ್ನ ಸೀಲ್ಡ್ ಕವರ್ ನಲ್ಲಿ?
ಅಲ್ಲ, ಅದು ಕನ್ಕ್ಲೂಡ್ ಆಗ್ಬೇಕು.
ಕನ್ಕ್ಲೂಡ್ ಆಗ್ಬೇಕು.
ಹೌದು.
ಯಾವಾಗ ಕನ್ಕ್ಲೂಡ್ ಮಾಡ್ತೀರಿ ಅಂತ?
ಅಲ್ಲಲ್ಲ, ಎರಡಿದೆ. ಒಂದು which is
ಒಂದು ಈಗಾಗಲೇ ಲೆವಿಡ್
ಅದು is challenged and it is pending.
ಚಾಲೆಂಜ್ ಇನ್ WP failed.
ಹೌದು. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಅದೇ ಒಂದು ಮೇಲೆ UPSC ಕನ್ಸಲ್ಟೇಷನ್ ಗೆ ಕಳ್ಸಿದ್ರೆ ಅದ್ ಬಂದ ತಕ್ಷಣ ಡಿಸಿಪ್ಲಿನ್.
ಅದು ಎಷ್ಟು ವರ್ಷ ಅಂತ?
ಇಲ್ಲ, ವರ್ಷಗಳಾಗಲ್ಲ. ವರ್ಷಗಳಾಗಲ್ಲ. ಯಾಕಂದ್ರೆ ಇದು ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು. ಇಟ್ ಇಸ್ ಫಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲಿ ಬಂದು ರಿಮಾಂಡ್ ಆಗಿ ಮತ್ತೆ ಹೋಗಿ ಹಿಯರ್ ಆಗಿ ಕನ್ಕ್ಲೂಡ್ ಆಗಿರೋದು. ಈಗ ಆರ್ಡರ್ ವಾಟ್ ಎವರ್ ಹಿಸ್ ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ ಇಸ್ ಚಾಲೆಂಜಿಂಗ್. ಬಿಕಾಸ್ ಆಫ್ ದಿ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ವಿ ಕುಡಂಟ್ ಪ್ರೊಸೀಡ್ ಫರ್ದರ್.
ಅದು UPC ಏನ್ ಮಾಡಿದೆ ಅನ್ಕೊಂಡು ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾರು ಅಪೀರ್ ಆಗ್ತಾರೆ? ಅವರು ಪಾರ್ಟಿ ಅಲ್ವಾ? UPC is not a party.
Not a party.
UPSC party ಮಾಡಿ. You make
No, my
UPSC.
lord, it is not the issue.
Huh.
My only issue is that review DPC has no power to resort to sealed cover. Because it will consider the vigilance angle only prevailing at the time of original DPC. At the time of original DPC, he was.
So where is the review DPC? They are calling it
yes,
as review
it is-
DPC.
Kindly see page 58 onwards, 58.
ಮೇಲ್ ತಾವು ಹೆಡ್ಡಿಂಗ್ ನೋಡಿದ್ರೆ ಮಿನಿಟ್ಸ್ ಆಫ್ ಮೀಟಿಂಗ್ ಆಫ್ ರಿವ್ಯೂ DPC ಅಂತ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Where is the review DPC? They are called it review DPC. By that, it does not become review DPC. Review DPC is a concept in service jurisprudence when it will be reviewed, where already a decision is taken. Subsequently, they want to review that decision.
Yes, my lord.
That becomes a review DPC. That happened here.
Yes, my lord. Original DPC was conducted in March 2018.
What was the outcome of original DPC?
Original DPC, because APR dossier was not available, therefore their case was not considered,
Deferred.
deferred.
Your case was deferred. That will not be.
My lord, there are DPT very clear instructions. Kindly see page 73 and 74.
ಪೇಜ್ 48 ತಾವು ನೋಡಿದ್ರೆ ಫಸ್ಟ್ DPC ಇದು ಪೇಪರ್ಸ್ ಇದೆ. 48. 46 ಇಂದ ಶುರು ಆಗುತ್ತೆ. 48 is the relevant minutes. ಅದ್ರಲ್ಲಿ ಮಿನಿಟ್ಸ್ ಆಫ್ ಮೀಟಿಂಗ್ ಆಫ್
ಎಷ್ಟು ಜನರದ್ದು ಕನ್ಸಿಡರ್ ಆಗಿತ್ತು ಅವತ್ತು?
ಅವತ್ತು 30 ಜನದ ಡೆಫರ್ ಆಗಿತ್ತು. ಟೋಟಲ್ ಬಂದು
It was deferred because records were not available.
ಹೌದು.
Yes,
ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದೋಸ್ 30 persons ಇವರು ಒಬ್ಬರ ಹೆಸರು ತೋರಿಸ್ತಾ ಇದ್ದೀರಿ. ಇನ್ನ 29 ಜನದ್ದು ಇತ್ತು. ಅಲ್ಲಿ ತಾವು ಹೆಡ್ಡಿಂಗ್ ನೋಡಿದ್ರೆ ಲಿಸ್ಟ್ ಆಫ್ 30 IRS ಆಫೀಸರ್ಸ್ ಆಫ್ ಆಫೀಸರ್.
ಯಾರ್ದು ಆಗಿಲ್ಲದು? No decision was taken in that, this one?
ಇವ್ರದ್ದು ಮಾಡ್ಲಿಲ್ಲ, ಬೇರೆಯವ್ರದ್ದು ಮಾಡಿದ್ರಿ.
ಬೇರೆಯವ್ರದ್ದು ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆಯವ್ರದ್ದು ಮಾಡಿದ್ರಿ. ಈ 30 ಜನದನ್ನ ಡೆಫರ್ ಮಾಡಿದ್ರಿ ಬಿಕಾಸ್ ಆಫ್ ನಾನ್ ಅವೈಲಬಿಲಿಟಿ ಆಫ್ ದಿ ಇಸ್
ಕರೆಕ್ಟ್ ಡೆಫರ್ ಆಗಿತ್ತು ಅಂದ್ರೆ ರಿವ್ಯೂ ಆಗಲ್ಲ ಅಂತ ನಮ್ಮ ಇಂಪ್ರೆಷನ್.
ಹೌದೌದು. It can't be termed as review by the time.
So you have called it as review unless that is considered first.
ಹೌದು. ಅಲ್ಲಿ
There
consider
is no question of review.
ಹೌದು.
It is only a deferred proceeding
ಹೌದು.
taken up on the next date,
Again,
then decision was taken.
ಹೌದು.
So it's not a case of review
Not
DPC at all.
reviewing his case, or it was considered on that day and again reviewing it for any reason. Page 48 ತಾವು ನೋಡಿದ್ರೆ list of so and so batch in whose the assessment has been deferred due to non-availability of complete dossier of.
So it was a
apart.
case of deference.
ಹೌದೌದು.
Review ಆಗದಿಲ್ಲ.
ಹೌದು. ಅದರಲ್ಲಿ serial 6 ಅಲ್ಲಿ ಇವ್ರದಿತ್ತು. ಇದ್ರ ನೆಕ್ಸ್ಟ್ ರಿವ್ಯೂ ಅಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ರಿವ್ಯೂ. ನೆಕ್ಸ್ಟ್ DPC ವಾಸ್ at page 58 onwards. Relevant page is page 60. Page 59. Serial 7.1 ಅಲ್ಲಿ it is mentioned that his name is mentioned.
Para 8 you have read it, na? Deferred.
ಹೌದು. ಅದಾದ್ಮೇಲೆ 306 ಜನ ಆಫೀಸರ್ಸ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದಾರೆ 2012 ಪ್ಯಾರಾ 9 ಅಲ್ಲಿ.
Paragraph
9 please. The committee has made assessment in respect of
306
officers of 2012 and 2013 batch of IRS. That is annexure 2 ಅದರಲ್ಲಿ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು. ಇದ್ರಲ್ಲಿ ತಾವು ಆಮೇಲೆ
ಇವ್ರದ್ದು ಕನ್ಸಿಡರ್ ಆಗ್ಲಿಲ್ಲ.
ಇವ್ರದ್ದಾಗ್ಲಿಲ್ಲ.
Because documents, records were not available.
Records were not available.
ACRs not available.
ಅಪಾರ್ ಇಲ್ಲ. ಅಪಾರ್ದು ಅದೇ ಯಾವುದು ACRs ಇಲ್ಲ. ಇದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ DPC ಆಗಿರೋದು page 58. Relevant page is 59. ನೆಕ್ಸ್ಟ್ ತಾವು page 59 ನೋಡಿದ್ರೆ 7.1. ಇಲ್ಲಿ administrative
7.1.
ಹೌದು 7.1 ಅದಾದ್ಮೇಲೆ ಟ್ಯಾಬ್ಯುಲರ್ ಕಾಲಮ್ಸ್. ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಮಂಜುನಾಥ್ ಐ ಪೂಜಾರ್, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಸೋನ್ಸು, a charge memo number so and so dated so and so is pending. ವಿಜಿಲೆನ್ಸ್ ಕ್ಲಿಯರೆನ್ಸ್ ಆಗಿದೆ 7.2 ನಲ್ಲಿ ಅದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ದೇ ಹ್ಯಾವ್ ರೆಸಾರ್ಟೆಡ್ ಫಾರ್
Committee considered the case of so and so in light of report and to put his case in sealed cover.
Page 62 serial 4.
7.2 also they said.
ಹೌದು. ಆ 7.2 ನಲ್ಲಿ ವಿಜಿಲೆನ್ಸ್ ಆಂಗಲ್ ಕ್ಲಿಯರೆನ್ಸ್ ಇದೆ, ಸ್ಟೇಟಸ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್. Page 62 ನಲ್ಲಿ serial number 4 ನಲ್ಲಿ it is mentioned recommendation of the committee has been put in sealed cover because of this.
Entire para 7 belongs to Manjunath only.
ಹೌದೌದು, ಇವರು ಬರುತ್ತೆ.
What the tribunal, sir, now you are saying that it's a review DPC.
Yes, my lord.
We are not agreeable with that proposition.
Kindly see page 58, it starts minutes of the meeting of review DPC.
They have said all that.
Yes. But when one original DPC has already conducted,
Where was the DPC held so far as you are concerned?
March 2018,
2000?
original DPC was held.
Where is that?
It is at page
Please. The page 46.
47,
46 ಇಂದ ಶುರು ಆಗುತ್ತೆ, 47,
46 onwards.
48 relevant.
No, your case was not considered at all because records were not, ACRs were not available.
My lord, it was considered because my name was considered, but I was not considered for promotion.
No.
My case was considered.
Please come to, kindly come to.
No, my case was deferred because then there was no fault on my part.
No, that's all right. Question is not that. Question
Hmm.
is it a review DPC or not?
Department
Reading
is,
these things, we do not go by the nomenclature of the
yes, my lord.
proceedings.
Department is accepting that it was review DPC number 1.
No, we don't agree with that.
Number, kindly see DOPT instructions.
Eh?
Kindly see DOPT instructions at page 73 and 74.
73.
73 DOPT instruction 21st November 2002. Instructions of sealed cover procedure applicable to review DPC. The undersigned is directed to refer to so and to say that a question whether the sealed cover procedure to be followed by review DPC has been under consideration of this department in light of the decision of the CAT in certain cases. The matter has been considered in consultation with the Ministry of Law, and it has been decided that sealed cover procedure as contained in the OM dated 92 cannot be resorted to by the review DPC if no departmental proceeding or criminal prosecution was pending against the government servant concerned, or she was not under suspension at the time of meeting of the original DPC, or before promotion of his junior on the basis of recommendation of the original DPC. His juniors were promoted in original DPC. Then there is next circular of 2014 at page 74. This also reiterates and further clarifies the first OM. The undersigned is directed to refer to Department of Personnel of even number dated 2012. This 2012 says that original DPC has power of sealed cover.
You are structuring your submission on the premise that the second consideration is a review DPC. We are not agreeing with that.
But my lord, it also says if his junior was promoted in original DPC, then this review DPC or second DPC cannot resort to sealed cover. If we don't consider it review DPC, okay, it was second DPC. If in first DPC his junior was promoted, then this applicant will also be promoted. He cannot be resorted to sealed cover. It is further clarified in this page 74, 2014 circular. For purpose of vigilance clearance for review DPC instruction exists on 2002 that review DPC will take into consideration the circumstances obtaining at the time of original DPC and any subsequent situation arising thereafter.
No, subsequent situation arises means?
Thereafter, charge sheet was issued subsequently.
Charge sheet was issued subsequently?
Yes, subsequent to original DPC, before review DPC. And any subsequent situation arising thereafter will not stand in the way of vigilance clearance for review DPC. However, before the officer is actually promoted, it needs to be ensured that he is clear from vigilance angle, and the provision of para 7 of 92 are not attracted. The department has been receiving references seeking clarification on grant of.
What is this para 7 OM?
92 again says that.
Please take us to that paragraph.
92 circular, is it? Have you filed a copy of 92 circular?
14992 in ಹೇಳ್ತದೆ para 7.
ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಸ್ಕೀಮ್ ಗೈಡ್ಲೈನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಹೇಗೆ DPC ಮಾಡಬೇಕು, ಏನ್ ಪ್ರೋಸೆಸ್ಸು, ಕ್ಲೌಡ್ ನಲ್ಲಿ ಯಾವಾಗ ಬರ್ತಾರೆ ಅದಿರೋದು.
ನಿಮ್ಮಲ್ಲಿ ಇದೇನದು?
It was instructions regarding original DPC. But copy is not available now.
We can't interpret. We are feeling little hesitant to accept your
Then
second submission where juniors are promoted.
Yes.
Then whatever is pending against you cannot be considered. That will be.
That is more clarified in next para, my lord.
We have seen that, but we cannot construe it the way you are construing it.
In para next is, the matter has been examined in consultation with the Department of Legal Affairs, and it is further clarified that in case of review DPC, where a junior has been promoted on the recommendation of the original DPC, the officer would be considered for promotion if she is clear from vigilance angle on the date of promotion of junior, even if the provisions of para 2 of DOPTOM of 92 get attracted.
How this is treated by the tribunal?
Tribunal only kindly see page 28. 28 para 18 of the tribunal order, we are in agreement with the learned counsel for the respondents that the department has followed the rule position as well as legal mandate, and in doing so, depending on just one or two OMs as done by the applicant is not appropriate.
How are you sustaining this? How many OMs, 100 OMs need to be
ಇಲ್ಲ,
produced
ಇಲ್ಲ,
to
ಇಲ್ಲ.
depreciate? One
90
OM. This is what you have told the people. We are doing this.
Milots, the OM which my learned friend is relying is Milots of a review DPC.
Of?
Review DPC. When they are doing
No,
the
no, review DPC illatigally. Even then, where there are two things. Where it is deferred is one thing. Where you are giving promotion to the juniors is another. He is harping upon the second part.
Second part, Milots, it's not that he will not be given promotion or anything. It is only entire process is done. It is kept in sealed cover. ಕೊಡೋದ ಅಂತ
A
ಏನು
sealed cover procedure, his contention is, you could not have resorted to that sealed cover procedure at all because of these OMs ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅವರು ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು 1992 OM clause 7 ಹೇಳ್ತಾ ಇದ್ದಾರೆ. May I just read that and pass it on, Milots? Milots, a government servant, that clause 7 though, a government servant who is recommended for promotion by DPC, but in whose case any of the circumstances mentioned in para 2 above arise after the recommendation of DPC are received, but before he is actually promoted, will be considered as if his case has been placed in a sealed cover by DPC. He shall not be promoted until he is completely exonerated of the charges against him, and the provisions contained in this OM will be applicable in his case also. May I just pass?
We have understood. Go to page 74.
Please.
That is clarified. That paragraph is clarified in the OM dated 23 January 2014. Come to para 3.
Please, Milots.
Two and 3.
Please, Milots.
Read 2 and 3.
This department has been receiving references seeking clarification on grant of promotion in cases of review DPC with regard to the
We clear from vigilance angle on the date of promotion of the junior
in the
original DPC, but subsequently attracts the provisions contained in para 2.
Idರಲ್ಲಿ
Mundogi.
my lords may kindly note, my lords, para 2 second line, case of if it is of review DPC, my lords,
Correct.
and from the vigilance angle.
To
Iವ್ರದ್ರಲ್ಲಿ
para 3.
vigilance angle it was cleared, my lords. Which-
Para 3 note.
Please note, the matter has been examined in consultation with the Department of Legal Affairs, and it is further clarified that in the case of review DPC, where a junior has been promoted on the recommendations of original DPC, and the official would be considered for promotion if he or she is clear from vigilance angle on date of promotion of the junior, even if the provisions of para 2 of
are
DOPT
attracted.
so on so gets attracted on the date of actual promotion is considered as provided and so. Milots, here, Milots, if there is a promotion, Milots, the official will be considered for promotion, Milots, if he is or she is clear from vigilance angle.
Correct.
That it is clear, Milots. In his case, there is no
He is
doubt.
banking upon this.
Please, Milots. On the date of promotion of the junior, even if the provisions of para 2 of DOPT OM 19
Still applicable. Even then you have to
get
give
that
promotion.
ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ವಿಜಿಲೆನ್ಸ್ ಆಂಗಲ್ ಈಗ this clarification is given for comprehensive review of instruction pertaining to vigilance clearance for promotions. Heading ತಾವು ನೋಡಿದ್ರೆ in what respect this clarification is given may be kindly considered, Milots. Comprehensive review of instructions pertaining to vigilance clearance for promotion clarification. That's the main subject.
Correct.
There, my lords, in para number, first para, it refers to for the purpose of vigilance clearance for review DPC. It says that. Second para, for review DPC in third. Instructions exist in ON number so and so, 21/11/2022, that review DPC will take into consideration the circumstances obtaining at the time of original DPC, and any subsequent situation arising thereafter will not stand in way of vigilance clearance for review DPC. Vigilance clearance, you ಕೊಟ್ಟಿದೆ. We are not disputing that. I pointed out, Milots, vigilance clearance given. There is no dispute. However, before officer is actually promoted, it needs to be ensured that he or she is clearance vigilance angle and the provision of para 7 of OM dated so and so 4992 are not attract.
Are not attracted.
ಹೌದು. ವಿಜಿಲೆನ್ಸ್ ಆಂಗಲ್ ಕ್ಲಿಯರ್ ಆಗಿರಬೇಕು ಹಾಗೆ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು, ಅದಾಗ್ಬಿಟ್ಟಿದೆ ಈಗ. ಅವಾಗ ಮುಂದೆ ಹೋಗ್ಬಿಡ್ತದೆ.
ಇವ್ರು ಹೇಳ್ತಾ ಇರೋದು.
In other words, this virtually amends para 2 and para 7 of 1992 guidelines. The author of the guidelines, 92 guidelines ಯಾರು?
It is also
Same.
DOPT.
Virtually, it silences or at least it interprets. The author of the first instrument of 92 is interpreting what is meant by paragraphs in the 1992 orders.
Clarification ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
That goes in his favor.
My submission would be this, Milord, subject to correction. Milords, these cases, this clarification, these two OMs which my learned friend is relying will be applicable when there is a review DPC which has been done, Milords, not otherwise.
Review DPC, correct. One thing, review DPC ಅಲ್ಲಿ ಎರಡಿದೆ. Where your case is considered and kept in sealed cover.
Please.
Where juniors are promoted, avag it's a different scenario contemplated under this, sir. There need not be multiple circulars which the tribunal wants. How many circulars tribunal wants? 1 or 2 under, how many he should produce? He will produce only one.
Milords, on that, I can't, something with some clarification is done, even one is enough, Milords, if it clarifies the issue.
One swallow makes not the summer, which Shakespeare said. That does not apply to this.
Milords, maybe the reasoning of the tribunal saying that idu produce ಮಾಡಿದರದು ಇದರದು ಸರಿ ಇದೆಯೋ ಇಲ್ಲೋ ಆ observation may be wrong, Milords. I don't support that. But my lords may kindly consider, Milords, when it was done, it was deferred, it was considered vigilance angle, it is cleared, Milords. And after that, after consideration, it comes to his promotion is done, Milords, and it is sealed cover is followed, Milords. Because of 2 DPCs, Milords, which were there, Milords, unless that is completed, because 1992, even the 1992 has to be seen. 1992 circular
would not be seen ಅಂತಾರೆ ಇವರು.
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ
ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬಿಟ್ಟು ಬಿಡಬೇಕು ಅಂತ.
ಹೌದು, ಅದು ಬಿಡಬೇಕು ಅಂತಾರೆ, ಆದ್ರೂನು ಕ್ಲೌಡ್ ನಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ. ಐ ವಿಲ್ ಜಸ್ಟ್ ರೀಡ್ ಔಟ್ ಒನ್ಸ್ ಅಗೇನ್.
ಯಾವುದು? 7 of 92.
ಹೌದು.
You cannot read that. Because you have to read the latest clarification given by the department, who is the author of the guidelines.
My respectable submission, Milords, it will be in respect of vigilance clearance in that OM. It can't be the entire thing. ಯಾಕಂದ್ರೆ vigilance clearance ದ clarification ಮಾಡ್ತಾರೆ. ಅಥವಾ
ಹಂಗಿದ್ರೆ para 2 ಬೇಕಾಗೋದಿಲ್ಲ ಅಂತ ಯಾಕೆ ಹೇಳ್ತಾರೆ? But subsequently attracts the provision contained in so and so and so.
Three ನಲ್ಲೂ ತಾವು ನೋಡಿದ್ರೆ it is clarified that in case of review DPC.
In the case of review DPC ಅಂದ್ರೆ ಏನು? ಮತ್ ಒಂದ್ಸಾರಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಡೆಫರ್ ಆಗಿತ್ತಾ? ಅದು one scenario. One second. It is one scenario. Your case was not considered at all. Is your stand. Therefore, it is not review ಅನ್ನೋದು.
ಹೌದು, ರಿವ್ಯೂ ಬರಲ್ಲ. ಇದು
understood. Whether you call it as review DPC or not, if juniors are promoted, where promotion is taking place of all these people in a wholesale way, there is no issue at all. Then those provisions would be attracted. Where you are giving promotion to juniors, then this provision, this circular comes to our aid, another contention. Our reasoning appears to be very different.
Reasoning.
Independently, we have to, as you rightly said, we may not agree with that, but still we have to consider this aspect, another one factor.
I have to make some research and submit my notes on the.
Further, my lord, in this case, the applicant was required to be promoted from the date of original DPC. Whether it was review DPC or second DPC does not make much difference. Because his junior was promoted from original DPC date, therefore he is also entitled.
If we accept your contention, that amounts to saying, wherever junior is promoted, whether my records are clean or not, I should be given the promotion. No question of resorting to sealed cover anta ಹೇಳ್ದಂಗೆ ಆಗ್ತದೆ.
My lord, at the time
Paid
of
proposition.
promotion of junior,
My lords, in all the.
fairness will be considered at the
Subject to
time of.
Very idea of sealed cover arises when juniors are granted.
ನಾ ಹೇಳ್ತಾ ಇರೋದು, ಈಗ ಜೂನಿಯರ್ ಈಗ ಲಿಸ್ಟ್
That happens as a matter of course.
ಕನ್ಸಿಡರ್ ಆಗೇ ಆಗುತ್ತೆ. ಇಟ್ ಇಸ್ ಕನ್ಸಿಡರ್ಡ್. ಕನ್ಸಿಡರೇಷನ್ ಇಸ್ ನಾಟ್ ಡೆಫರ್ಡ್ ಮಿಲ್. ಇಟ್ಸ್ ಕನ್ಸಿಡರ್ಡ್ ಕೆಪ್ಟ್ ಇನ್ ಸೀಲ್ಡ್ ಕವರ್. ಅದಲ್ಲದೆ
ಇಲ್ಲಿ ಒಂದು ಡಿಫರೆನ್ಸ್.
ಪ್ಲೀಸ್ ಮಿಲ್.
See, if some juniors are also there and these 30 were not considered. So, but if they had not given effect to those juniors, simply they had postponed,
Would have agreed with you.
would have agreed with you. But they consider some of it.
ಹೌದು, 306 ಜನ
They
ಕನ್ಸಿಡರ್
take
ಮಾಡಿದ್ದಾರೆ.
decision on that.
ಹೌದು.
ಇದ್ರೊಳಗೆ ನಮಗೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದು ರಿವ್ಯೂ ಆಗುತ್ತೆ ಅಂತ.
ಹೊರಟೋಗುತ್ತೆ.
ಹೌದು 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 ಹೌದು, ಅವ್ರದ್ದೆಲ್ಲ ಇಶ್ಯೂ ಆಗಿದೆ.
Clear ಆಗಿದ್ಯೋ?
ಅದಿದೆ.
ರಿವ್ಯೂನೇ ಆಗುತ್ತೆ.
ಹಂಗಾಗಿ ರಿವ್ಯೂನೇ ಆಗುತ್ತೆ.
ನಾನ್
ರಿವ್ಯೂ ಆಗುತ್ತೆ.
ವಾಟ್
ಈಗ ಹೋಲ್ಸೇಲ್ ವೇ ಯಾರ್ದು ನೋಡ್ದಂಗೆ ಆಗಿದ್ರೆ ವುಡ್ ಹ್ಯಾವ್ ಅಂಡರ್ಸ್ಟುಡ್.
ಮೈ ಲಾರ್ಡ್ ಸರ್,
ಇವ್ರಷ್ಟು ಜನ ಕ್ಲಿಯರ್ ಅಂತ ಅನ್ಸುತ್ತೆ ನಮ್ಗೆ. ಇವ್ರದ್ದು ನಾವು ನೋಡ್ಬೇಕು,
ಹೌದಾ?
ಆಮೇಲೆ ನಾವು ತಗೋಬೇಕು.
ಅದು ರಿವ್ಯೂನೇ ಆಗುತ್ತೆ.
ಎಲ್ಲಾನು
ಅಂದ್ರೆ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಲಿಲ್ಲ ನಮ್ಮ. ಹೌದು,
ಅವಾಗ ಆಗ್ತಿರ್ಲಿಲ್ಲ.
ಎವ್ರಿಥಿಂಗ್ ವಾಸ್ ಪೋಸ್ಟ್ಪೋನ್ಡ್.
Postponed, it would not have amounted to review. You, for set of officers, you have already taken a decision. Only for them,
in
you
respect of
have
that,
deferred with intent to review.
if it is term minutes, 3 ಜನಕ್ಕೆ it was referred, deferred, postponed or for review, it can be taken whatever manner it is. My submission is this, minutes, subject to.
Already have taken a decision. ಅದಕ್ಕೆ second level ಗೆ review ಆಗುತ್ತೆ.
Subject
ಅದು
to.
review ಅಂದ್ರೆ section
ಅಲ್ಲಲ್ಲ,
113 of CPC review ಅಲ್ಲ, order 47 review ಅಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಅದಲ್ಲ.
Review in the sense.
ಅಲ್ಲ, ಏನಾದ್ರು ಮಾಡಿದ್ರು ಅದು ಮತ್ತೆ ನೋಡ್ಬಿಟ್ಟು
ನೋಡ್ತಾ ಇದ್ದೀವಿ.
ಒಂದು ಪರಿಮಿತಿ. ನಂದು ವಾಟ್ ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಮೇಕ್ ಇಟ್ ಔಟ್, ಮಿಲಟ್ಸ್, it's not that there is any connection with the department or the DPC. DPC is independent, milots. Records are sent across. And sometimes, milots, due to non-availability or something, milots, it happens. It's not intentional.
Unusual ಅಂತೇನಲ್ಲ,
ಇಲ್ಲ.
ಅಥವಾ intentionally ಮಾಡ್ಯಾರ ಅಂತನೂ ಅಲ್ಲ.
ಅವ್ರಿಗೂ ಏನಂತಂದ್ರೆ they would have fixed a time, milots, that ಇಷ್ಟರಲ್ಲಿ ಆಗ್ಬೇಕು ಅಂತ. So whatever is available in respect of 306 officers, they have done it. In respect of 30 officers, when it was not there, milots, they have deferred it. And milots, it's not that his case after that, when it came, it is not considered or done anything. It was considered, whatever it is available to him, it is given, and it's just kept in a sealed cover procedure because he was under cloud. So it is.
ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ ಅನ್ನೋದು ಅವ್ರ ಕಂಟೆಂಟ್.
ಅಲ್ಲಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರೆ ಆ ರೀತಿ ಆದ್ರೆ ಮಿಲಾಟ್ಸ್ ಈಗ ಡೆಫರ್ ಆದಾಗ ಬೇರೆ ಜೂನಿಯರ್ಸ್ ಯೂಶಲಿ ಇಟ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ ಯಾರ್ದೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇತ್ತು ಅದಾಗೆ ಆಗತ್ತೆ. If that is the case, milots, the deferring or later on reviewing or giving it, again kotrunu, it will be from that date itself. It will be from the date when the first thing was done, milots. It's.
Let us assume that the charge member was issued prior to first DPC.
Please, milots.
In that case, in the.
Clear, milots. It's clear. There is no.
But whether there was a charge member prior to it was also not available.
ಆ ಇನ್ಫಾರ್ಮೇಶನ್
Nothing, my lords.
Information available.
Our file ಇಲ್ಲ.
ಇಲ್ಲ.
File ಇಲ್ಲ.
So, as on date of the first DPC, whatever the situation was there, that should have been the consideration.
ಹೌದು, ಅದೇ their contention is. ಹೌದು, ಅವ್ರ contention.
Subsequently ನಾವು ಮುಂದೆ ಮಾಡ್ತೀವಿ. ಮಧ್ಯದಲ್ಲಿ ನೀವು ಚಾರ್ಜ್ ಮೆಮೊ ಕೊಟ್ಕೊಂಡು ಸೇರ್ಸ್ಕೊಂಡ್ರೆ
ಹಂಗ ಆಗ್ಬಾರ್ದು ಅನ್ನೋದು ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಸರ್ಕ್ಯುಲರ್.
ಹೌದು, ಅವ್ರ contention ಅದೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. He is saying that first DPC ಆಗ್ಬೇಕಾದ್ರೆ nothing was there against me. It has come later on. So consider the case of the first DPC ಮಾಡಿ ಅಂತೇಳಿ. I am trying to say, my lords, just I will assume, my lords, their contention is.
ಒಂದೇ ಸೆಕೆಂಡ್. ಅಲ್ಲಿ ಇವ್ರ ಮೇಲೆ ಏನು ಕ್ಲೌಡ್ ಇದೆಯಲ್ಲ, ಯಾವ ಡೇಟಿಗೆ ಇತ್ತದು?
ಅದು ಪ್ರೀವಿಯಸ್ ಟು ಇವನ್ ಬಿಫೋರ್.
Previous to that
ಹೌದು
also.
ಹೌದು.
Not that it is
ಅವಾಗ ಆಮೇಲೆ ಬಂದಿದ್ದಂತಲ್ಲ, ಅದಕ್ಕಿಂತ ಮೊದಲು.
It was there. Information was not available.
It was there earlier ones. ಎರಡಿದೆ, ಎರಡು ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ. ಒಂದರಲ್ಲಿ
Any decision on service law side which say it amounts to review DPC. Review DPC ಅಂತ ಡಿಫೈನ್ ಏನಾರ ಆಗಿದೆ ಎಲ್ಲಾದ್ರೂ?
ಇಲ್ಲ, ಗೈಡ್ಲೈನ್ಸ್ ನಲ್ಲಿ ಅದು ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ರಿವ್ಯೂ DPC ಮಾಡ್ಬೋದು, ಡೆಫರ್ ಮಾಡ್ಬೋದು ಅಂತ ಆತರ ಗೈಡ್ಲೈನ್ಸ್ ನಲ್ಲಿ ಇದೆ. ಜಜ್ಮೆಂಟ್ ಇಲ್ಲ, ಬಿಕಾಸ್ ದೇ ಫಾಲೋ ದಟ್ ಪ್ರೋಸೆಸ್.
If one decision has been taken to promote and then again a review has to be done, whether our previous decision is correct or not ಅನ್ನೋದಾಗ ನಾವು ರಿವ್ಯೂ ಅನ್ನುವಂಥದ್ದು ನಮ್ಮ ಕನ್ಸೆಪ್ಟ್ ನಲ್ಲಿ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೋದು.
ಲೀಗಲಿ ಇಲ್ಲಿ ಬೇರೆ ಆಗ್ತದೆ.
ಇಲ್ಲ,
ಆ ರಿವ್ಯೂನ ಸ್ಕೋಪ್ ಇದೆಯಲ್ಲ,
ಹೌದು, ಅದ್ರ ಮೀನಿಂಗ್
something else.
Correct.
It may be a small thing also, it may be a big thing also.
Correct.
Usually what happens, Munaz, ಈ DPC ನಲ್ಲೆಲ್ಲ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ it won't be the same body or whoever the person. ಅದು ಏನಾಗ್ಬಿಡುತ್ತೆ, every time it changes. ಈ ಫಸ್ಟ್ DPC ನಲ್ಲಿ ಯಾರು ಕೂತಿರ್ತಾರೆ ಅವ್ರು ಇರೋಲ್ಲ, ಮತ್ತೆ ಚೇಂಜ್ ಆಗ್ತದೆ. It's only on the record basis they go on what it is there and details which is there. ಆ ರೀತಿ strictly it will not go before them only. It changes every time, it changes.
ಇದರಲ್ಲಿ ಅವರೇ ಇದ್ದಾರೆ.
It was within.
They are there, but what he says is true. They will go on.
Lot of it's not only one department, all the department DPCs, everything will be going on. Milords, they will our time based irutte. Ish time ನಲ್ಲಿ ಬರಬೇಕು ಆಗಬೇಕು ಅಂತ ಹೇಳಿ ಎಲ್ಲ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. This issue is
charge memo. When charge memo was issued to you?
October.
When charge memo was issued to you?
October 2018.
To
October 2018.
October 2008, 30/10/2018. It was there. The DPC takes place discreetly or in the presence of the officers?
No, only DPC members.
Only DPC members.
Yes.
ಇವ್ರನ್ನ ಹಿಯರ್ ಮಾಡೋಲ್ಲ, ಯಾವ ಆಫೀಸರ್ಸ್ನು ಹಿಯರ್ ಮಾಡೋಲ್ಲ.
ಇಲ್ಲ.
DPC ನಲ್ಲಿ ಆತರ ಬರಲ್ಲ, ಸುಮ್ಮನೆ ಆಪರ್ಚುನಿಟಿ ಕೊಡೋದು ಆತರ. They see the records and
charge memo was issued on 10th October 2008, 30th October 2018.
Petitioner contention is accepted, my lords. Then when the DPC happens, my lords, if it is when the promotion takes place, juniors ಇದ್ದೇ ಇರ್ತಾರೆ.
That always happens.
ಯಾವಾಗ ಇದ್ದೇ ಇರ್ತಾರೆ. ಅವಾಗ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಇವ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಮತ್ತೆ
very purpose of that seal cover will be defeated ಅನ್ನೋದು ಒಂದು argument.
ಹೌದು, Supreme Court decision is if someone is there or charge is issued or charge sheet is filed against them, till it's conclude, they have to do it. For that only that process was done. My lords, here it is not that he will be denied any promise.
Kindly come to para 3 of page 74.
Yes. The matter has been examined in consultation with the Department of Legal Affairs, and it is further clarified that in case of a review DPC, where a junior has been promoted on the recommendation of the original DPC, the official would be considered for promotion if she is clear from vigilance angle on the date of promotion of the junior.
For the purpose of that para 9 of 92 is reproduced. Para 9 of 1992 guidelines is reproduced there. Let us see that.
Yes.
For the purpose of vigilance clearance for review DPC, instructions exist in OM number so and so will take into consideration the circumstances obtaining at the time of original DPC and any subsequent situation arising thereafter will not stand in the way of vigilance clearance for DPC. However, before the officer is actually promoted, it needs to be ensured that he or she is clear from vigilance angle and paragraph 7 are not attracted. This is not a subsequent situation at all. Subsequent situation means the charge memo is issued to you subsequently. If the charge memo is issued to you earlier, but information is not available about that, that will not inure to your benefit. Because it was charge memos was issued on 31/10/2018 itself. So the expression subsequent situation is in the sense, it should be construed in the sense that charge memo is issued subsequently. Not the charge memo was issued earlier, but information about that was not available to the DPC. Such things are not contemplated. We are not construing some provisions of penal legislation of Westminster Abbey.
Yes, yes, my lord.
We are only construing the office memorandum.
Yes, my lord.
This one. If you are, as on that date, you are clouded, then they would have again put it in the sealed cover procedure only.
There is one more situation, my lord. There is only one DPC, suppose, and DPC clears his name on 1st April, suppose. His actual promotion is issued on 20th April, and he is issued one charge sheet on 15th April before actual promotion. Then his promotion will be withheld.
Correct.
Yes, ma'am.
Correct.
Yes,
But that supports our view now.
yes, ma'am.
Now, we are not only in
Yes,
one single case,
Yes, ma'am.
because what we say
Yes, ma'am.
will be applicable to rest of the people as a procedure.
Yes, ma'am.
Now, the idea of subsequent situation, any subsequent situation arising thereafter, the expression which they have used, though we are not construing any
Yes.
provisions of a statute.
Yes.
How the officer concerned has structured this is, any subsequent situation arising thereafter means, in your case, issuance of charge memo after the sitting of the first DPC.
Yes, ma'am.
ಆ ಸೆಂಟೆನ್ಸ್ ತಾವು ಪೂರ್ತಿ ನೋಡ್ಬಿಟ್ರೆ ಒಂದೇ ಒಂದ್ಸರಿ ವಿಲ್ ನಾಟ್ ಸ್ಟ್ಯಾಂಡ್ ಇನ್ ದ ವೇ ಆಫ್ ವಿಜಿಲೆನ್ಸ್ ಕ್ಲಿಯರೆನ್ಸ್ ಫಾರ್ ರಿವ್ಯೂ DPC ಅಂತ ಹೇಳಿ.
Correct.
ಸೊ ವಿಜಿಲೆನ್ಸ್ ಕ್ಲಿಯರೆನ್ಸ್
No,
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಿ.
we'll go one step further in his favor. Even then we are saying this. If we take up that one, in other words, vigilance clearance has to be issued even if subsequent
Charge is
something
also
has
there.
issued.
It is there also, then give it ಅಂತ. ಅದನ್ನ
But
ಕೊಟ್ಟಿದೆ.
this is not that case. This is a case where already charge memo is issued.
Yes.
So, as on the first DPC itself, the sealed cover should have been followed.
Yes, ma'am.
So, if that is so, they have followed it in the subsequent DPC, will not give a cause of action to you.
Then there was no need of review subsequent DPC.
That may be.
Yes, my lord.
It's not a subsequent DPC.
Yes, yes.
The question is, he should have suffered sealed cover procedure. In fact, it's an advantage actually. At the first DPC itself, that is being done at the second DPC. No error, no cause of action. That may be an error,
Yes, ma'am.
but that does not give you a coherent cause of action to challenge it. We may not agree with the reasoning of the CAT is another thing, but you have to show not only order of the tribunal is wrong, it is unsustainable also. That second part appears to be tough for you. We have just
But then-
contemplated what all the consequences.
Then, my lord, if there was a sealed cover in original first DPC, then there was no need of second DPC.
At all.
Yes, my lord.
That's right.
Yes, ma'am.
Yenilla. We have done the exercise after hearing you. But you assisted very well. You clarified certain the blocks, mental blocks of ours arising from these things. Though we do not broadly agree with the approach of the tribunal in expecting multiple OMs, comma, the order of the tribunal makes sense in as much as the petitioner was issued the charge memo on 30/10/2018 itself. And therefore, on the first DPC, the right course was to, would have been
ಆದ್ರೆ ಇದು
the second DPC. That is, first DPC and the DPC held on 31/12/2018. The charge memo was already issued.
No, my lord, that was
ಅಲ್ಲಲ್ಲ
that was second
ಫಸ್ಟ್
DPC,
DPC ಡೇಟ್ ಬಂದು
27 March 18, my lord.
23/7/2018.
Yes, no.
ಹೌದು ಫಸ್ಟ್ DPC 27th March.
Subsequently.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಬಂದು
30/10/2018 DPC, is it called as review DPC? Charge memo issued on 30/10/2018. No, 23/7/2018. That was deference case.
ಹೌದು
Therefore, 31/12/2018 ಆಗೋದು case of deference ಅಲ್ಲ, ಆಗಲ್ಲ, review ಆಗದೇ ಇಲ್ಲ. Because the case is deferred. If case of these people were to be considered and deferred Allah. Case of these people was not considered at all because required info was not available. Therefore, it is not a case of review DPC at all. We are holding it that way.
My lord, it may be not review DPC, it may be second DPC, it may be consequential DPC, any type. But the issue is when junior has been promoted from the date of original DPC, then my client will be also promoted from that date. Because at the time of original DPC, when junior was promoted, there was no vigilance angle pending.
The promotion, whatever it is there, which he is entitled, he's been done and kept in cover. It's not that he's not been promoted at all.
No, that is not the issue.
Seat cover procedure ಆಫ್ ಮಾಡಬಾರ್ದಿತ್ತು ಅಂತ.
ಹಂಗಾದ್ರೆ ಜೂನಿಯರ್ಸ್ ಹಾಗೆ ಆಗ್ತಾರೆ, ಎಲ್ಲ ಹೋಗಿ ಹೋಗುತ್ತೆ.
ಅವ್ರ ಇದು contention is first DPC was on 23/7/18. As on 23/7/18, whatever
nothing against me.
was there, that should have been considered.
ಅದರಲ್ಲಿ ಎರಡು ಪಾರ್ಟ್ ಬರ್ತಾ ಇದೆ. ಒಂದೇನಂತಂದ್ರೆ ಈಸ್ ರಿಲೈಯಿಂಗ್ ಆನ್ 2 OM. ಫಸ್ಟ್ OM melodies is dated 21st November 2002, wherein it specifically deals with the review DPC. ಹೇಗೆ ಯಾವಾಗ ಏನು ಅಂತೇಳಿ. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ OM ಯಾರ್ದು ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಇಟ್ ಈಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ವಿಜಿಲೆನ್ಸ್ ಕ್ಲಿಯರೆನ್ಸ್ melodies. That is 23rd January 2004.
If at the time,
First one melodies.
ಆ ಡೇಟಿಗೆ ಯಾಕೆ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ ಅವ್ರ ಕೇಸು?
Lord, if at the time,
DPC.
ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಲಿಲ್ವಲ್ಲ.
ಅವಾಗ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದ್ರು, there was no case against him.
ಅಲ್ಲಲ್ಲ ಅವಾಗ ರೆಕಾರ್ಡ್ಸೇ ಇಲ್ಲ ಏನು.
Correct.
Fact remains now.
ಬಂದಿದ್ರು one.
If it had come.
If the information was available,
Let us assume that it was available.
then nothing was there.
No case against
Nothing was there. Then cloud ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ, sealed cover ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ.
Why you deferred only because you had no information about the candidate? One second. You had no information about the candidate.
ಹೌದು.
Even if information was available, my brother is saying, there was nothing against him.
ಅಲ್ಲ ಚಾರ್ಜ್ ಏನಾದ್ರು ಇಶ್ಯೂ ಆಗ್ಬಿಟ್ಟು ಫಸ್ಟ್ ಟೈಮ್ ಚಾರ್ಜ್ ಏನಾದ್ರು
ಅವಾಗ ಇಶ್ಯೂ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ, ಅವಾಗ ಡೆಫರ್ ಆಯ್ತು ಎಲ್ಲರೂ 30 ಜನದ್ದು.
ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇಶ್ಯೂ ಆಗಿದೆ.
ಅದು ಆಮೇಲೆ ಆಯ್ತು. ಅವಾಗ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವಿಜಿಲೆನ್ಸ್ ಕ್ಲಿಯರ್ ಇತ್ತು, ಇದು ಚಾರ್ಜ್ ಇತ್ತು ಅಂತ ದೇ ಹ್ಯಾವ್ ಡನ್ ದಿ ಪ್ರಮೋಷನ್ ಪಾರ್ಟ್, ಇಟ್ ಇಸ್ ಡನ್ ಅಂಡ್ ಕೆಪ್ಟ್ ಇನ್ ಸಿಲ್ ಕವರ್.
ಅದು ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ.
ಹೌದು.
As on the first day.
Why 30 people's information was not sent to DPC?
ಯಾರು ಕಳಿಸ್ಬೇಕಿತ್ತು ಅದನ್ನ?
ಅಲ್ಲ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಸೆಂಡ್.
ಅದನ್ನೇ
ಯಾಕೆ ಕಳಿಸಿಲ್ಲ?
306 ಜನದ್ದು ಕಳಿಸಿದ್ದಾರೆ, ಇದು ಮಿಸ್ ಆಗಿದೆ.
ಕಳಿಸಿಲ್ಲ.
What is his fault ಅಂತ?
Well, he is not at fault. I will not put anything on him to say it's the records has to be sent by the department. I can't say he's at fault. that's not. ಇವ್ರೊಬ್ಬರದೇ ನಂದೆ ಅಂತಂದ್ರೆ ಇವ್ರೊಬ್ಬರದೇ ಎಲ್ಲ 306 ಜನ ಪ್ಲಸ್ 30 ಜನ ಇಷ್ಟು ಜನದು ಹೋಗ್ಬೇಕಾಯ್ತು. 306 ಜನದು ಹೋಗಿದೆ, 30 ಜನದು ಅದರಲ್ಲಿ ಪ್ಲಸ್ ಇನ್ ಅಡಿಷನ್ ಇವ್ರದ್ದು ಮಿಸ್ ಆಗಿದೆ. Some situation has arisen later on that is considered, my lords. Otherwise, my lords, if benefit is given to the petitioner applicant, my lords, the whole purpose.
ಚಾರ್ಜ್ ಏನು?
My lords, one charge, it is in respect of absenteeism, my lords.
Absenteeism.
He proceeded on leave by filing application without prior sanction.
ಅಲ್ಲ, ಇನ್ನೊಂದು ಬೇರೆ ಚಾರ್ಜ್ ಏನು?
Because that he has not produced, my lords.
No, your senior friend is performing his case so beautifully and so in a very well appreciable manner. How to deny relief to him on the contention?
Let's say I have not, let's if it was not affecting the entire, ಈಗ ಅದೇ ಈ ತರದೊಂದು ಆಯ್ತು ಅಂದ್ರೆ ಎಲ್ಲ ಕಡೆ ಆಗುತ್ತೆ. Then my lords, the purpose of holding any sealed cover procedure will be different. Any junior will be promoted, my lords. It will be there.
ಅಲ್ಲ, ಇವ್ರ ಜೊತೆನೆ ಆಗಂಗಿದ್ರ ಡೀಲ್. ಇವ್ರದ್ದು ಇಟ್ಕೊಂಡು ಜೂನಿಯರ್ಸ್ ಅನ್ನು ಮಾಡ್ತೀವಿ.
ಹೌದೌದು.
As on that day, there was nothing against him.
Yes, my lords.
That is his hard work.
Yes, yes. That's true.
If subsequently something happens, that is governed by these OMs ಅಂತ ಅವ್ರ contention.
Lords,
One step ahead, he has not argued it. One step ahead. Purposefully, these 30 people's information
Cases
was
is not
sent.
sent at all.
lords,
ಅಲ್ಲ,
With
assuming.
some
ಅದಲ್ಲ,
intent
will
and
assume, my lords.
somebody.
ಏನೋ ಮಾಡಿದರೆ ಬೇಕಂತ
ಮಾಡಿದ್ದಾರೆ.
ಕಳ್ಸಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಂತಾನೆ.
ಅವಾಗ DPC ಅವರು ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
ಈಗ
DPC ಅವರು ಇಲ್ಲ ನೀವು ಅದನ್ನು ಕಳಿಸಿ ಒಟ್ಟಿಗೆನೇ ನಾವು
ಎಲ್ಲರದ್ದು ನೋಡ್ತೀವಿ ಅಂತ ಹೇಳೋಕಿತ್ತು.
ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
Because securing information is the duty of the DPC. Because these proceedings are held discreetly. ಇವ್ರನ್ನ ಯಾರು ಕರೆದಿರೋದೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳ್ದೆ.
ಇಲ್ಲ
ಇವ್ರನ್ನ ಕರೆದ್ರೆ ಇವ್ರು ಹೇಳ್ತಿದ್ರು ನಮ್ಮ ಮೇಲೆ ಏನು ಇಲ್ಲ ಇದೆ. They would have said. ಅವಾಗ ದಿ ಸಬ್ಸೆಕ್ವೆಂಟ್ ಸಿಚುವೇಶನ್ ಅರೈಸಿಂಗ್ ದೇರ್ ಆಫ್ಟರ್ ಇದೆಯಲ್ಲ, ಆ ಕೇಸ್ನ ಬಂದ್ಬಿಡ್ತು.
ಹೌದೌದು.
Therefore, it has to be excluded. If that is so, sealed cover could not have been done. Just ನಮಗೆ
My lords, it oscillates. My lords may kindly appreciate the larger interest, my lords. If that is the case, ಅವಾಗ ಯಾರನ್ನು
ನೋಡೋಣ, ಇದು ನಾವು ರಿಸರ್ವ್ ಮಾಡ್ತೀವಿ.
larger interest may be kindly
No, not only that, the way he has put forth that case with so much meticulousness.
My lords,
that,
he is from the department, my lords. Earlier he was in the department, so he knows.
He
the
knows
process.
everything.
He
But
was
even the way he has put forth.
retired as a
that is-
commissioner of income tax, so he is aware of the process, how it happens. And we take a cue sometimes from him and here we argue that
So
that's
he
the
uttered
different thing.
so beautifully. And the much ado signifying nothing ಅಂತಾನಲ್ಲ ಶೇಕ್ಸ್ಪಿಯರ್ ಅಂತದೆಲ್ಲ ಕೆಲವರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಏನೇನೋ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ, ಸಾಕಾಗಿ ಹೋಗ್ತದೆ. It's so simple and elegant.
It's on point, my lords, on point that this is the,
Appears to be that way.
ಏನಂತಂದ್ರೆ my lords may kindly appreciate the larger interest that.
ಅಲ್ಲ,
One
DPC ಗಳು ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದನ್ನು ಒಂದ್ ಸ್ವಲ್ಪ
ಹೇಳ್ಬೇಕಾಗ್ತದೆ.
Please, please.
ಅಂತ ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ದಾಗ ಎಲ್ಲರನ್ನೂ ಡೆಫರ್ ಮಾಡ್ತೀವಿ. ಇಲ್ಲೊಬ್ಬ ಜೂನಿಯರ್ಸ್ ಮೇಲೆ ಬಂದು ಕೂತ್ಕೊಂಡ್ಬಿಡಿ. ಆಮೇಲೆ they will generate something against him.
ಆಮೇಲೆ
Not in this
seniority
case.
ಸರಿ ಮಾಡಿ ಇದನ್ನ ಸರಿ ಮಾಡಿ
ಮಾಡಕ 20 ವರ್ಷ ಹಿಡಿತದೆ. ನಮ್ಮ ಸ್ಪೀಡಿಗೆ 20 ವರ್ಷ ಬೇಕು. Judiciary. Yeah. We are, Valkivala used to say, if you compare the way the judges are conducting the proceedings to the tortoise movement, tortoise will file defamation case against you because we are not that slow.
Let's off record ಹೇಳ್ತೀನಿ. ಇವ್ರದ್ದು ಏನ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್, ಮೀನ್ಸ್ ಆಫ್ ರೆಕಾರ್ಡ್. ಇವ್ರದ್ದು ಏನ್ ಕನ್ಸಿಡರೇಷನ್ ಅರ್ಲಿಯರ್ ರೌಂಡ್ ನಲ್ಲಿ ಇಟ್ ವಾಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಸ್.